Previous session we have discussed about union executive and state executive, article 5278 and 153 to 167. In this session we shall discuss about union legislature from article 79 to 122. Okay, article 79, 80, 81 talk about composition of parliament, constitution of the parliament, composition of council of states, composition of house of people. Council of State and House of the People are called Rajya Sabha and Lok Sabha, and these terms are adopted as Hindi translation post 1954. Okay, but the constitution mentions these terms. And okay, article 82 talks about a delimitation commission, that is readjustment of recenses, and you are going to see the duration of each houses. So basically Rajya Sabha is the elder house and Lok Sabha is the younger house, so I am going to take a Rajya Sabha first. So the composition of Rajya Sabha discussed under article 80 clause 1, and composition of Lok Sabha is discussed under article 81 clause 1, and whereas the duration for the Rajya Sabha is discussed under article 80 subclause 1, whereas the duration for the Lok Sabha is discussed under article 83 subclause 2. Okay, and coming to qualification for the membership of the parliament, we need to read it alongside with the disqualification provisions under article 101 to 104, alongside with representation of people act of 1951, which talks about both the qualifications and disqualifications to be a member of parliament. And after that we are going to see sessions of the parliament, prorogation and dissolution, and here you are going to see the difference between adjournment, prorogation and dissolution. Okay, this is article 85, and article 86 talks about the right of the president to address and send messages to each of the houses. Article 87 special address by the president, and article 88 rights of the minister and attorney general as respects to the houses. Okay, so we are going to discuss all these articles, and in the next part we are going to discuss the officers of the parliament, who are nothing but the presiding officers. And the first 4 articles talk about the chairman and deputy chairman of the council of state, that means Rajya Sabha, and the next 4 articles talk about speaker, deputy speaker of the house of the people, that is Lok Sabha. And after finishing the 8 articles, we are going to cover the salaries and allowances of the chairman and deputy chairman, speaker and deputy speaker, that is salaries and allowances of the presiding officers of both the houses. And secretariat of the parliament is given under article 98. He is the highest cabinet office, highest civil ranking IAS officer. It is so the provision for the cabinet secretary, the secretary general of the parliament, it is mentioned in article 98, who is an highest ranking IAS officer. We are going to discuss some of the powers and functions of this IAS officer later. And next we are going to see how the business is conducted in the parliament. And article 90 talks about oath or affirmation by the members, and article 100 talks about voting in houses, vacancies and quorum. Okay, disqualification of the members, we have already discussed that. It is from 101 to 104. Okay, and here in the disqualification for membership, you are going to see it has 2 subclause, subclause 1 and subclause 2. Subclause 2 of 102 talks about anti-defection law, which is added to the constitution by 52nd Constitutional Amendment Act of 1985, which is going to talk about defection for MPs under article 102 clause 2. I think for MLAs it is 192 clause 2. Let me recheck. So there is a mistake here. It is 102 clause 2, and if you add 89 to it, it is 191 clause 2, subclause 2. Okay, so anti-defection law talks about disqualification for MPs and MLA, that is the provisions are given for MPs in 102 clause 2. And after this we are going to see some of the powers, privileges and immunities of the parliament and its members from 105 and 106. Okay, and later from the 107 they are going to be very interesting articles. From 107 to 114. Okay, from 107 the articles are going to be very interesting. You are going to see the difference between money bill, ordinary bill, financial bill and constitution amendment bill, and you are also going to note down a very important term, the important difference between financial and finance. So basically all the financial bills are not the money finance bills, because financial bills under article 117 are subclassified into fin-A and fin-B bills, where fin-A bills are classified under money bills, but fin-B bills are not classified under money bills. So finance bills are receipts in the union budget. The term, remember one thing, that the term union budget is not mentioned in the constitution. There is only the term annual financial statement. It is under article 112. So we are going to see the split of annual financial statement into receipts and expenditure, and again the receipts are nothing but finance bills under article 110. Matlab they are the money bills, matlab fin-A bills, whereas and the expenditures are brought into the parliament from appropriation bills, which is under article 114. Article 115 talks about supplementary, additional and excess grants. Article 116 talks about vote on accounts, vote of credits and exemption grants. We are going to look into the difference of everything, and we have already discussed about Article 117, and later we are going to see the general procedures in the House, the language to be used in the House, restriction on the discussion in the Parliament, and 122 is a very important article. It talks about courts not to inquire into the proceedings of the Parliament, which says that for example, if Rahul Gandhi uses hate speech against the government inside the Parliament, then such speech cannot be questioned in the court of law. So because Article 122 provides immunity to the members of the Parliament to not be inquired or not be questioned in the court of law. Now let us discuss the first 5 articles. Okay. Article 7, you already know the trick, right? 5 to 78. So 52 to 78, it's the executive. So the articles from legislature starts from 79. So coming to article 79, it talks about the constitution of the parliament. It says that the president, Lok Sabha, president house, parliament consists of a president, house of the people and council of states. One thing you remember is that president is part of both executive and legislature. And the next thing you need to remember is that in United States it is the different. In United States the president is not part of US Congress. US Congress is nothing but another term for parliament in United States. So in United States the president is not part of US Congress, and the US Congress only consists of representation, House of Representatives. It only consists of House of Representatives and the Senate in the United States. Whereas if we observe the British, our constitution has drawn this structure from the British pattern, which has a crown in place of president, and in place of House of People they have House of Commons, and in place of Council of States they have House of Lords. Okay. And one thing you need to remember is that Lok Sabha and Rajya Sabha are local terms, and House of the People, which is mentioned in the constitution, is sometimes also called as House of Representative, Popular House or Populist House. Council of States, sometimes it is also called as Federal House, Elders House or Intellectuals House. Why we are calling Rajya Sabha is an intellectual house? Because intellectuals like S.J. Shankar, who is an ex officio IFS officer, he is an IAS officer, whereas Manmohan Singh, he was an IAS officer. So all the intellectuals are joining as MP in the Rajya Sabha. So that is why we are saying that we are also calling Rajya Sabha sometimes as the intellectuals house. Okay. And we have finished the constitution of the parliament, article 79. Now let us look into article 80, composition of council of states, and article 81, composition of the house of the people, Lok Sabha. So summarizing both of the articles together, and the entire articles can be split into 2 categories. Okay. See, the constitution only mentions the maximum strength, and out of this the statutory limit, Representation of People Act 1951, it talks about the actual strength, whereas constitution talks about the maximum strength. So the constitution, for what is the source for Rajya Sabha and what is the source for Lok Sabha. So article 80 clause 1 talks about the maximum strength of Rajya Sabha, and this need to be read alongside with fourth schedule. If you know the tiers of old PM, so R stands for fourth schedule. So in this fourth schedule, it is again subclassified into for example, fourth schedule says the number of seats allocated to each state to Rajya Sabha. For example, it says that from Bihar constituency 4 seats must be given to 4 seats must be given to be elected to Rajya Sabha. Okay. Similarly, in Madhya Pradesh 25 seats must be given. So all these are not the actual numbers, but for example I am saying, so such distribution is given in the fourth schedule. So according to this distribution, and this is one of the source, and reading article 80 clause 1 alongside with fourth schedule, we are saying that the maximum strength of Rajya Sabha is 250, which is given in under article 80 clause 1, whereas the number of members to be elected from the states and 3 union territories, it is as per fourth schedule. Okay. Now looking into this, 80 clause 1, 81 clause 1, maximum strength is 250, maximum strength is 550 here, and when I need to get the actual strength, I am descending the number, it is 245, and here I am descending, it is coming 543, descending order. And next I am going to remember that 12 members are always nominated by the president, this is always constant, and these members are nominated in the fields of literature, arts, science and social service. Just remember it as BA, BSc. So I can remember arts, science, and I can remember literature and social service. So these 12 members nominated by the president are from these 4 fields, and when I am subtracting this number, I am able to get a number of members elected from Rajya Sabha, maximum strength of Rajya Sabha. So I am able to get number of members elected from states, 28 states and 3 union territories. One thing you note down is that in the elections of the Rajya Sabha, only 3 union territories participate, whereas when it comes to elections in the Lok Sabha, all the 8 union territories participate. Okay, one more thing is that in Rajya Sabha, indirect elections takes place, whereas in Lok Sabha, direct elections take place. And one more thing, there are no members that are nominated in the Lok Sabha. Before 2019, 2 Anglo-Indians under Article 331 used to be nominated. How many Anglo-Indians? 2 Anglo-Indians used to be nominated by the president under Article 331. However, that provision was repealed post 104th Constitutional Amendment Act of 2019. And similarly, in the state legislature, if you observe, there used to be a provision of Article 333 where governor used to nominate 1 Anglo-Indian to the legislative council, to the legislative assembly, but that provision was also repealed by the 104th Constitutional Amendment Act of 2019. So you are clear with the maximum strength and you are clear with the minimum strength, actual strength, and you know that 12 members to be nominated, so you will get the number of members who are indirectly elected from states and union territories. And similarly here you are going to remain 20 from the union territories and 19 from the union territories. So number of members elected from the states is going to be just the subtraction. Okay, and one thing I need to remember, when a tricky question comes in the exam, if they ask you how was the seat distribution before 2019, then you know that currently in 2025, I know that out of 543, 19 go to the union territories, and if I subtract 19, it's going to be 524 in the states. Now, so it is 524 in the states and 19 in the union territories. I am going to subtract 6 seats because I know that Jammu and Kashmir has 5 seats. See, before the abrogation of Article 370, Jammu and Kashmir used to be one single state, but after the abrogation of Article 370, Jammu and Kashmir split into 2 union territories. Jammu and Kashmir is UT with legislature and Ladakh is UT without legislature. So UT without legislature, Ladakh, it has only 1 seat represented in the union territories in the Lok Sabha, and Jammu and Kashmir, it has 5 seats. Okay, now before 2019, 6 seats they used to be in the state, so I am just going to subtract 6 here and add here. I will get 530:13. Okay, but this is my question before 2019. But if I ask you a question, what if in future Jammu and Kashmir becomes a state, then how the seat distribution is going to be? So there are 524 states and 19 union territories, right? So Jammu and Kashmir has 5 seats. So now I am just going to subtract 5 seats from the 19 union territories and I am just going to add it here. So it is going to be 529 in the states and 14 in the union territories. Okay, yeah, this is okay. Now we have finished composition of Council of States, composition of the House of the People, and we also know the source. We know the source for the maximum strength is from Article 80 clause 1. Source for the maximum strength in the Lok Sabha is under Article 81 clause 1, and you know that this is the source for the maximum strength, whereas the actual strength comes from the statutory body, that is Representation of People Act of 1951 Statutory Act. It says that it gives provisions for the actual limit, and also Representation of People Act 1951, it also talks about 6 states which has legislative councils. Okay, what are the 6 states with legislative council? Telangana, Andhra Pradesh, Karnataka, Maharashtra, Bihar, Uttar Pradesh. Okay, these are the 6 states with legislative council, and RP 9151 provides the provision for this. Okay, let us not deviate from the topic. So Article 80 subclause 1 gives the provision about the maximum strength of Rajya Sabha. 81 clause 1 talks about maximum strength for the Lok Sabha, and the actual, but whereas the actual limit is the provision for the actual limit is given in Representation of People Act 1951 for the Lok Sabha, but whereas for Rajya Sabha I don't think there is no such statutory act for it. Directly after the abrogation of Article 370, the seat distribution, seat matrix has been changed, and since the number of seats given to the states is already fixed, there is a loss of 5 seats from the states, so it is basically 238 minus 5. So currently only 233 members are elected from the states and 3 union territories, so I am subtracting, I am getting 245. And let us see what Article 82 talks about. Article 82 says about the readjustment after each census. That means it talks about the delimitation commission. It says that upon the completion of each census, the allocation of seats in the House of the People to the states and a division of each state into territorial constituencies shall be readjusted. So readjustment after each census, the same thing I have repeated in a formal language. Okay, so the first census was conducted after the first general elections of 1950. So it is 1951. 1950, after 1951 there is a 1952 Delimitation Commission Act. Similarly after 10 years there is a 1962 Delimitation Commission Act, and continuing till 1971 there is 1972 Delimitation Commission Act. However, in 1971 the census was fixed to 1971 by 42nd Constitutional Amendment Act of 1976 to incentivize the northern state to control the population control measures, just as how the southern states have control. And if the census had not been fixed, then the southern states wouldn't have got the would have been discouraged that despite following a population control measure they were not able to secure seats in the parliament. So that is why the census was fixed to 1971, and 42nd Constitutional Amendment Act of 1976 allowed delimitation based upon the 1971 census until 2000. But when the 2001 came, there is again 84th Constitutional Amendment Act of 2001 which extended this delimitation to 2026. Okay, and but in the year 2003 again there was 87th Constitutional Amendment Act of 2003 which allowed delimitation based upon the 2001 census. Okay, so this delimitation is only for altering the shape of the constituencies but not changing the number of seats. For example, let us say that this is my state of Andhra Pradesh, and they are divided into territorial constituencies. Okay, and now the population of constituency 1 has been increased and the constituency 2 has been tremendously decreased, but still an MP is represented from the two constituencies, MP1 and MP2. So as per constitution the population to the number of constituency ratio must be same. Okay, therefore Parliament chose to use the 2001 census only for adjusting the territorial shape of the territorial constituency, but not to alter the number of seats. So what are the number of seats in the diagram that I have drawn now? 1, 2, 3, 4, 5. So the number of seats are going to be the same. They are not going to be increased to 10 just because the population of the state has been increased, but the shape of the constituency is going to change so that the population divided by the number of seats is going to remain constant. Okay, that is 87th Constitutional Amendment Act of 2003. So you are clear with the all the delimitation commission, and you are clear with why 1971 census is still being used. Okay, and the next delimitation commission is going to come in 2026. Okay, I have a question for you. Why PT Usha was given Rajya Sabha seat in the why PT Usha has been given Rajya Sabha seat in the sports quota? Because just now you have studied that there are only 4 areas where president can nominate a person to the seat of Rajya Sabha. What are they? Literature, arts, science, social service. So sports quota do not belong to this. Then why PT Usha was given seat in Rajya Sabha? And then Supreme Court declared that the categories of nomination are indicative and are bona fide by the president, and they cannot be challenged in the court of law. Okay, that you need to remember. So I have one more question for you. Are the seats reserved? What are the seats reserved in Lok Sabha and Rajya Sabha? Are there any seats that are reserved in Lok Sabha and Rajya Sabha? There are no seats reserved in Rajya Sabha. Okay, there are no seats reserved in Rajya Sabha. Whereas in Lok Sabha, the seats are reserved for SCs and STs, but whereas no seats are reserved for OBCs, women, and EWS. And do you know that there are certain seats that are reserved for women after Women's Reservation Bill of 2023, which was successfully passed in the Parliament. And according to this, 1/3 of the seats will be reserved for women. Okay. But however, this was not implemented yet, and it will take effect from 2026 after Delimitation Commission has come up with the changes. Okay, and the provisions for this is mentioned in part 16 of our constitution. So now we have to see the reservation of state seats in the Lok Sabha and Rajya Sabha. For this, let us look into our constitution once. Okay. But before looking into constitution, I will give you a brief review. This is reservation of seats in the Lok Sabha and Rajya Sabha. Yes, the seats are not reserved in Rajya Sabha, whereas seats are reserved in the Lok Sabha for SCs and STs, and for OBCs, women, and EWS. And for women, currently no seats are reserved, but if Delimitation Commission pass and the seat distribution is changed, then it is going to be implemented, and this provision is given in Article 334 Clause A. Article 3, Women Reservation Bill of 2023 introduced three new articles into the constitution. One is 330A, which said that 1/3 of the seats must be reserved for women in Lok Sabha. 332 Clause A, 1/3 of the seats should be reserved in the Legislative Assembly of each state. 334A, this effect shall take place post delimitation 2026. Okay, this talks about seats to be reserved in the Lok Sabha in Parliament in future. Okay, similarly, when I check for SCs and STs, Article 330 talks about seats to be reserved for SCs and STs in the Lok Sabha, and Article 332 talks about seats to be reserved in the Legislative Assembly. See, if I notice for both the women and SC and ST, it is the same 330, 332, 332. Lok Sabha, Legislative Assembly, and yeah. When I'm checking, when I checked till when this provision is valid, till when SCs and STs will be able to get reservation in the Parliament, have checked that this provision is given in Article 334 Clause A, which says that this reservation shall cease to exist after 80 years from the date of enforcement of this constitution, matlab from 1950. So when I add 80 years to 1950, it is going to be 2030. So reservations in the Lok Sabha for SCs and ST shall cease to operate post 2030. This 80 was amended by 104th Constitution Amendment Act of 2019. However, this act did not bring any changes. See, Article 334 has two subclauses, 334A and 334B, and 104th Constitution Amendment Act of 2019 amended 70 to 80. That is how instead of 2020 we got the provision for 2030, and that is how there is an extension for this for the provision of reservation in Lok Sabha for SC and STs, whereas for Anglo-Indians it did not amend, and the reservation for two Anglo-Indians is in Lok Sabha did not extend further after 104th Constitutional Amendment of 2019, because this is just going to give me 2020, which is over 5 years back, which was over 5 years back. Okay, so we are back to our constitution. So part 16 of our constitution talks about special provisions to certain classes. Article 330 talks about reservation of seats for SCs and STs in the Lok Sabha. Okay, whereas whenever it is A, remember that it is about women. Okay, because see, I can find that Article 330A is talking about reservation of seats for women. reservation of seats for women in the House of the People, again in the Lok Sabha only. Okay. Whereas again 331 it is talking about Anglo-Indian community, reservation of seats for Anglo-Indian community. We have just seen this was repealed. This was completely repealed after 104th Constitutional Amendment Act of 2019. And coming to 332, it talks about reservation of seats for SCs and STs in the Legislative Assembly. So in the Legislative Assembly, whereas again here it is 332A. ये मतलब it is for women again. So I know that this is about Legislative Assembly. So it is going राज्यसभा, तो राज्यसभा में सीट्स रिजर्व होता नहीं है, तो लोकसभा में या फिर लेजिस्लेटिव असेंबली के बारे में हुआ होगा. सो इफ 330 and 330A are talking about Lok Sabha, 332 and 332A they are talking about Legislative Assembly, reservation of seats for women in legislative assemblies of the state. And Article 333, representation of Anglo-Indian community in the Legislative Assembly of the state. This was also repealed. The same thing, right? Governor usually before 2019, governor used to nominate one Anglo-Indian to the Legislative Assembly. However, post 104th Constitutional Amendment Act of 2019, that provision was completely repealed. Okay, and then 334 says that reservation of seats and special representation shall cease to operate after certain period. Yes, this certain period is that is what I have discussed. This certain period is okay. 334 has two subclauses, subclause 1 and subclause 2. Subclause 1 talks about SCs and STs, whereas subclause 2 talks about talks about Anglo-Indians. Okay, and SCs and STs in Lok Sabha and Legislative Assembly, Anglo-Indians in Lok Sabha and Legislative Assembly. So 104th Constitutional Amendment Act, what did it do? 104th Constitutional Amendment Act, it did extend to 80 years, but it did not extend Anglo-Indians ka provision. This was just left to 70 years, and now 70 years got over, and since 70 years were over, there are no seats reserved for Anglo-Indians in our Legislative Assembly and Lok Sabha. Whereas since it is to 80 years, when we add it to when we are adding it to 1950, we are going to get 30. So there now currently we are in 2025. So the seats will be reserved till 2030 in the Lok Sabha for SCs and STs, and Parliament need to bring some other amendment act to extend this provision further, which might be later. Okay, for now, yes, seats are reserved for SCs and STs. Yes, seats are currently not reserved for women, but yeah, this talks about these are the amendments, but they are not implemented because 334A. Again, 334A says that representation of seats for the women takes place post delimitation 2026. Okay, so I think you are clear. 330 is about SCs and STs, reservation of seats. 330 it is about reservation of seats in Lok Sabha. 332 is about reservation of seats in Legislative Assembly, and 334 talks about when the such extension shall be ceased, till when such provision is valid. Okay, and 334 it ceases till 2030 for SCs and STs. 334A it says that the reservations will be given post 2026 for women. Okay, now let us discuss about Article 83, duration of houses. So you know that this is Rajya Sabha. Let us say this is Rajya Sabha, and let us say that this is Rajya Sabha, this is Lok Sabha, and article composition is given by Article 80 subclause 1, Article 81 subclause 1, and duration is given under 83 subclause 1 and 83 subclause 2. Okay, now now I am talking about duration. So it is under 83 subclause 1, 83 subclause 2. And one thing I need to note down is that Rajya Sabha is a continuing chamber, whereas Lok Sabha is not a continuing chamber. Because why? Lok Sabha is subject to dissolution, but Rajya Sabha is never subject to dissolution. And 80 subclause 1 also says that the Council of State shall not be subject to disqualification, but 1/3 of the members shall retire every second year, filled through fresh elections and presidential nomination. That means, for example, this is my Rajya Sabha, and I am splitting it into 1/3, 1/3, 1/3. So they are first 1/3, second 1/3, and third 1/3. So it says that if a first 1/3, every 1/3 should retire for every 2 years. So after first general elections, the first 1/3 have been retired. So their term initially was 2 years, but the second 1/3 their term was 4 years, and the third 1/3 their term was 6 years. But after this third 1/3, when it came to the fourth 1/3, their term is also 6 years. Initially, after general elections for 4 years, there might be some irregularities, but after the retirement, once after the third 1/3 had been retired, the term period by default it became 6 years. Okay, term period for a member of Rajya Sabha is 6 years. So directly the constitution doesn't mention that the term period for the member of parliament in the Rajya Sabha is 6 years, but it says that every 1/3 shall retire every second year, filled with fresh election and presidential nomination. However, when you check Representation of People Act 1951, it directly provides a specification that the term of the member of Rajya Sabha shall be 6 years. Okay, but we need to always say that Rajya Sabha is a continuing chamber, and it is never subject to dissolution. Okay. And coming to Lok Sabha, the term period of 5 years is directly mentioned in Article 83 subclause 2. Okay, the House of the People, unless sooner dissolved, shall continue for 5 years. Matlab, if it is sooner dissolved, the term period shall be less than 5 years. But if it is already 5 years, then there will be automatic dissolution. Okay, and the same article, clause 2, 83 subclause 2 also says that during emergency, under article 352. Okay, emergency, what are the different kinds of emergency? Okay, so there is 352, there is 352 talks about national emergency, 356 talks about state emergency, and 360 talks about financial emergency, right? So you also know that suspension of fundamental rights is given under which article? 358. 358 talks about suspension of fundamental rights, which is inspired from Weimar Constitution of Russia. Okay, so during emergency, the term of Lok Sabha be extended for 1 year, and such extension shall cease to operate 6 months after the emergency end. I'll explain. So basically, this is my term period, and of 5 years, and in my last 1 year I have proclaimed an emergency. Let's say I am Indira Gandhi, so in the last 1 year I have proclaimed an emergency. So after proclamation of emergency, it is going to be extended for 1 year, but there is no restriction on number of times that can be extended. So I can extend it for n number of times. So the term period would, and after such n number of extensions, if I do not extend it further, the emergency automatically cease to exist after 6 months. So the term period of emergency, the term period of Lok Sabha during emergency can be 5 plus n plus 6. N is the number of times that I have extended the provision, plus 6 months. 5 plus n years plus 6 months is the term period of Lok Sabha during emergency. So before going into disqualifications, I just thought to revise once. So when you look into the constitution, you will see that under article 80 and article 81, composition. So one talks about 12 members to be nominated by the president under article 80 subclause 3, and similarly it also says that it also gives the maximum strength of the Lok Sabha. And subclause 2 talks about the allocation of the seats must be according to the 4th schedule, and it also says that president can be nominated in these 4 fields. And the same article subclause 4 says that representation of each seat from the Rajya Sabha should be as per elected MLAs. with in accordance with proportional representation by single transferable votes, and similarly representatives of UTs shall be chosen as per Parliament by law may prescribe. So this is given by the Representation of People Act of 1950. Similarly, in the Lok Sabha also, 20 seats are nominated from the UTs, right? So these representatives are from UTs direct election to the House of People Act of 1965. So and I also said that number of seats to the population of the states, population of the state, they must be same, and accordingly you will do the border readjustment, and accordingly you will check the number of seats to be given to the each constituency. Okay. We have seen that the qualification for membership, we need to study from here qualification for membership of Parliament. We have seen that this need to be read alongside with disqualification provisions from 101 to 104. But before that, let us discuss what are the provisions under Article 84. It says that the member must be citizen of India. If he is contesting to be MP of Lok Sabha, his age must be greater than 25, and for MP of Rajya Sabha, his age must be greater than 30. And next thing, it says that any qualification is given by Parliament by law. Parliament by law, what did it say? It gave Representation of People Act of 1950, and as per Representation of People Act 1951, it has a qualification and disqualification provisions. Let us look into both of them, and let us look into the disqualification provisions under 101 to 104. We have seen that Article 84 talks about the qualification, and it says that he must be citizen of India, greater than 25 for Lok Sabha and greater than 30 का एज फॉर राज्यसभा. एज लिमिट भी देख लिया. अब ना ये देखा कि रिप्रेजेंटेशन ऑफ पार्लियामेंट बाय लॉ कोई भी क्वालिफिकेशंस प्रोवाइड करती है तो वो भी सेटिस्फाई होना चाहिए. तो RPA 1950 के अकॉर्डिंग उसमें क्वालिफिकेशंस का प्रोविजन है, डिस्क्वालिफिकेशंस का प्रोविजन है. हम लास्ट में RPA 1950 क्या बोलते हैं वो देखेंगे. एंड देन we shall see that even if a member is qualified, that member shall not be disqualified, and disqualification provisions are given in 101 to 104. Let us see what they are. Okay, alongside with 84, he also must not be disqualified from 101 to 104. What is this? So basically 101 is talking about vacation of seats. नॉट ऑल 101 to 104. इसमें 101 तो वेकेशन ऑफ सीट्स के बारे में बात हो रही है. 102 की बात होती है तो इसमें डिस्क्वालिफिकेशन के बारे में है. डिस्क्वालिफिकेशन इसमें सब क्लॉज 1 है, सब क्लॉज 2 है, और सब क्लॉज 1 बात करती है ये से लेके एफ क्लॉजेस तक. एंड ऐसे मेंबर अगर इस तरह से डिस्क्वालीफाई होता है सब क्लॉज 1 के अंदर, देन दिस मेंबर ओके ऐसे मेंबर को कौन ओके दिस मेंबर the decision for the disqualification of a member subject to Article 102 Clause 1 shall be taken by the President, whereas the disqualification for the decision of the disqualification for a member subject to disqualification under 102 Clause 2 under 10th schedule shall be taken by the presiding officer, that is the President. And then this is 103 यही बात करती है President, President, this is the same thing. The President, upon the recommendation of Election Commission of India, shall decide upon the matters of disqualification under Article 102 Clause 1. And next 104 बात करती है penalty के बारे में. See, I have written the same thing here. 101 talks about the vacation of seats. 102 talks about disqualification for membership. It can be disqualified from A to F provisions या फिर under 10th schedule. We shall look into both of them, the disqualification for membership. This is very important, and the both 103 clause 1 and sub clause 2 are important. And next 103 decision on the qualifications as to disqualifications of members. Okay, this is taken upon this basically 103 only talks about 102 sub clause 1, that means A to F, and 104 talks about penalty for sitting and voting before oath or affirmation. So the disqualification for membership, it is from A to, so they are given under two subclauses. One subclause 1 which talks about A to F provisions. Let us see what they are, and let us also see the subclause 2 which talks about defection by 10th schedule, and the members are disqualified by the presiding officer, and the decision of the presiding officer shall be final. Whereas under A to F which talks about unsound mind, undischarged insolvency, etc. So such persons are disqualified by the President after the recommendation of Election Commission of India, which is final upon the President, which is binding upon the President. So disqualification for membership from subclause 1 A to F are by president, whereas disqualification under 10th schedule, it is by the presiding officer, that is the speaker or the chairman. And this provision, that is a president disqualifies members from article A to F, it is given by the Election Commission of India, right? It is given by 103 article subclass 1. So basically 103 talks about disqualification of members under article 102 clause 2. The decisions on such questions shall be taken by the president upon the recommendation of Election Commission of India, which is binding upon the president to accept. So you are clear with 103 and 4. 4 just says that if a member sits in the house without oath or affirmation, then such member shall pay a penalty of 500 rupees, and such penalty, however, can be recovered as a debt to the government. That means it can be recovered as a debt to the government. Okay. So basically oath or affirmation, it is mentioned in article 99, which says that oath or affirmation of the members is as per 3rd schedule. Okay, let us see it later. Now let us discuss about let us discuss about vacation of seats, and let us see the disqualification for membership. First let us discuss vacation of seats and then disqualification for membership from A to F, 10th schedule, and also as per Representation of People Act of 1950. It also says about qualification and disqualification, so let us see them later. So first let us see vacation of seats. So it says that article 101 talks about vacation of seats. It has the clauses 1, 2 talks about double membership. The seat shall be deemed to be vacant if a member holds double membership. So double membership can be so the provision for the double membership is mentioned in the constitution in clauses 1, 2 in 101, whereas some other in Representation of People Act 1951, which also says some other cases where double membership is possible. Example, if a member from house 1 goes to house 2, then the seat in the house 1 shall automatically deemed to be vacant. And if a member is if a member has 2 seats in both the houses, then the member shall be the seat in both the house shall be deemed to be vacant if the member do not choose within 14 days. Okay, house 1 to house 2, house 1 will be automatically vacant. It also says that if suppose this is the Lok Sabha, and if he is having 2 seats in Lok Sabha, then he need to choose within 14 days. If not, both will be vacant. And these are the provisions under double membership of Representation of People Act of 1951. But Representation of People double membership provisions are also given in the Constitution. It says that if a member if a member has seat in both Lok Sabha or Rajya Sabha, or both Parliament and the State Legislature. Okay, if he is having a seat in both Lok Sabha and Rajya Sabha, he shall decide within 10 days. This provision is given by Representation of People Act. So if he does not if within 10 days he do not choose, then the seat in the Rajya Sabha will automatically deemed to be vacant, and then the seat in the Lok Sabha will be fixed to him. So seat in the Rajya Sabha shall be deemed to be vacant. But what if this and this both are different, because here the member is going from house 1 to house 2 after elections. That means automatically house 1 will be vacant. But if a member is already in both the seats of Lok Sabha and Rajya Sabha after elections, then if we do not choose within 10 days, Rajya Sabha seat shall be deemed to be vacant. What about this 101 subclause 2? Prohibition of simultaneous, as per provision of simultaneous membership rules of 1950, these are the rules made by the president. Rules of prohibition of simultaneous membership or rules of 1950, which says that if the member do not choose within 14 days, see sabka 14 days here, if the member do not choose within 14 days, then सीट इन द पार्लियामेंट शिल बी वेकेंट. तुम अपना स्टेट में जाओ, MLA बन जाओ. सो दैट it says that if a member has seat in both the Parliament and State Legislature, the seat in the Parliament shall be vacant. Okay, and if a member is a part of Lok Sabha and Rajya Sabha, then the seat in the Rajya Sabha shall be vacant. If a member in house 1 goes to house 2, then automatically house 1 will be vacant. And if the member has 2 seats in Rajya Sabha, he need to choose any one. If not, both will be vacant. These are the provisions as per Representation of People Act. But if it is talking about Parliament and State Legislature, it is given under Prohibition of Simultaneous Membership Rules of 1950, which are made by the President. So this is about the vacation of seats during the double membership. However, there are other cases apart from double membership where a seat can be vacant when a member is disqualified under Article 102 subclause 1 or subclause 2. When a member is disqualified under Article 102 subclause 2, we have seen this, then the seat will be vacant. Disqualified by the President under Article 102 subclause 1, then the seat will be vacant. Or else if he is disqualified under 10th schedule by the Speaker or Chairman, then also his seat shall be deemed to be vacant. But also there is one more case where a seat can be vacant if he resigns. Okay, first talks about first two subclauses talk about double membership, and 101 subclause 3 subclause here talks about disqualifications, and subclause B talks about resignation. ओके एक तो वैकेशन से मतलब डबल मेंबरशिप से वैकेंट सीट मिल सकती है. सी व्हाट आई अंडरस्टूड इज़ दैट vacant seats can be due to double membership, and it is in 1, 2. Vacant seats can be due to disqualification. It is mentioned in Article 101 subclause 3. या फिर ये भी हो सकता है कि vacant seats can be also due to resignation. It is mentioned in sub 3A. Or vacant seat can also be if he is absent for more than 30 days, and it is mentioned in 101 subclause 4. See, if a member resigns to the presiding officer, if a member resigns, then of course his seat will be vacant. And if a subclause 4, 101 subclause 4 says that if a member is absent for 60 days, more than 60 days, then his seat will be vacant. However, this does not include 4 consecutive days of adjournment in the Lok Sabha or Rajya Sabha. So see, in the 60 days it does not include 4 consecutive days of adjournment. Then it does when the Lok Sabha ऑलरेडी अगर हॉलीडे है लोक सभा में, तो उसको हम एबसेंट की तरह काउंट नहीं करेंगे. अगर 4 consecutive days से ज़्यादा एडजॉर्नमेंट है तो it is not counted under absence. So yeah, now I think you have got a clarity about vacation of seats, when the seats are vacant, when there is a double membership, when there is a disqualification of members under 1021 or 1022 10th schedule, or else 102 clause 1, or else he resigned to the presiding officer, or else he is absent for more than 30 days. One thing. Okay, I think you are clear. Now I am going to talk about disqualification for membership. Okay, disqualification for membership, we have seen that there is 1021 clause 1, which has provisions again subclauses from A to F, and 102 subclause 2, which has a provisions of which says that defection by 10th schedule and the decision of the presiding officer shall be final. Okay, so it says that disqualification for membership, as we have discussed it, 102 has subclause 1 and subclause 2. In subclause 1, it talks about several things from A to F, and subclause 2 talks about disqualification by 10th schedule, and Article 103 clause 1 clause 2, they together say that if a president so members, the decision of the president on the recommendation of Election Commission of India shall be final about on the disqualification of Article 102 subclause 1. मतलब the president shall disqualify a member if he is subjected to disqualifications under Article 102 subclause 1 A to F. So what are these A to F provisions? Let us see. So first it says that a person shall be disqualified for being as chosen as for being member of either house of the parliament if member shall be chosen. Okay, these are A to F provisions. First A, if the member holds office of profit under the government of India, if a person is of unsound mind, if a person is an undischarged insolvent, if a person is not a citizen of India or acquired a foreign citizenship of a foreign state, or if he or she if he is so disqualified by or under any law made by the parliament. For this we have Representation of People Act of 1951, which has certain provisions, and and it also okay, so there are only A to E provisions. Sorry, my bad, it is not A to F, it is just A to E. Okay, A to E, there are only 5 provisions. Okay, see, if he holds an office of profit under declared by parliament by law, any other office declared by parliament by law, and according to this, parliament has declared an law, some of the offices for this parliament has declared. Parliament prevention of disqualifications act, prevention of prevention of disqualification act of 1959. So according to this, parliament has exempted certain offices from disqualification. What are those offices? If a member is a chairman of NC and ST, National Commission for SCs and ST, then he is granted permission. That is not considered as an office of profit. And if a member is from a territorial army, then also he is not considered as a office of profit. Okay, so you are clear with this. And unsound mind, the term unsound mind is not mentioned anywhere in the constitution, not mentioned anywhere, therefore but anyhow there is this, it is not mentioned in the constitution, but we have Indian Contract Act of 1982, Indian Contract Act of Indian Contract Act of 1982, 1982, which defines which is not an unsound mind, and this Contract Act is being used by the Supreme Court to say whether a member is subject to the unsound mind or not. Okay, what is undischarged insolvency? It means that insolvency proceedings are pending in the court of law. Insolvency proceedings are nothing but see, a member is undischarged insolvent if this is the date of sentence and he is still undischarged, so he is an undischarged insolvent. This means he is already discharged. So a member who is undischarged insolvent is disqualified to be a member of parliament. Okay, and if a member acquires foreign state citizenship, then also is not a member. The main things you need to remember here is A, B, C: office of profit, unsound mind, undischarged insolvent. Okay, after A to E, we get to see that 102 subclause 1 got over, and subclause 2 says that if a member is disqualified under 10th schedule, okay, so 103 subclause 1 and 2, they both of them they clear that. So 1 says that the decision of the president shall be final, and 103 subclause 2 says that however the opinion of the election commission, the president shall obtain the opinion of the election commission and shall act according to the such opinion. So that is basically binding. So 103 subclause 1 and subclause 2 together says that clause 1 of article 102 is to be read with article 103, which says that the disqualification of a member under 102 subclause 1 is by the president. Okay, whereas this is by the disqualification is done by the president under the recommendation of election commission of India, whereas disqualification is done by the presiding officers on 10th schedule. Now I would like to ask you a question. So now we are clear with qualifications and disqualifications, right? Now we need to check with what are the qualifications and disqualifications as per Representation of People Act of 1950. So you already know vacation of seats. 101 talks about vacation of seats, and 102 it talks about disqualifications by एक तो by the president and दूसरा है by the speaker or chairman. President, yeah, this is given under article 103. Okay, so there are certain additional qualifications under RPA 1951. See, it is very simple. If a member is contesting for Rajya Sabha election, there is only one qualification criteria, that is he must be an elector of that particular constituency. However, if he is contesting for election for the Lok Sabha, there are three cases. Like, what if he is contesting for seat reserved in for the SC? What if the seat is reserved for ST? And what if it is any other seat? So if a seat is reserved for SC, then the person must also be SC, and but he can be registered voter from any constituency. Similarly, if a seat is reserved for ST other than any autonomous district of Assam, then the registered voter can be from any parliamentary constituency. If other than SC ST, the registered elector can be from any parliamentary constituency, and there is no restriction. However, if the seat is reserved in the autonomous district of Assam, he must definitely be ST, and the contester, he must be a registered voter in some autonomous district of Assam, or maybe some other autonomous district of Assam. Anyhow, he must be definitely from autonomous district. Okay, not necessarily Assam, but he must be from that autonomous district, from any autonomous district. So there is a UPSC mains question, because the salient features of representation of people act, it is a main topic in the UPSC mains. So the question is, on what grounds a people's representative can be disqualified under the Representation of People Act of 1951? Also mention the remedies available to such person against his disqualification. So the simple thing that you would say in your introduction is, just now I have studied that Article 102 talks about disqualification. Okay, 102 subclause 1 gives provision from A to E, and clause 2 talks about defection under 10th schedule. So I will say that Article 102 subclause 1 subclause 2 talks about gives criteria for disqualification for member of parliament, and Article 191 subclause 1 subclause 2 they give certain criteria for disqualification of members in the state legislature. Okay, disqualification of MLAs basically. Whereas 102 subclause 1 comes, they talk about disqualification for MPs. However, Representation of People Act of 1951 provides elaborates some more criteria, provides additional criteria, gives additional criteria on the disqualification of the candidates. Okay, let us see what are those criteria. Okay, what are the disqualification provisions under RP 1988? Okay, section 81, 82, 83, 4 sections under 8, 81, 82, 83, 84, 9A, sorry, it's not 84, it's 8A, 81, 82, 83, 8A, 9A, 10A. So what do they say? Section 81 talks about disqualification for promoting enmity between two groups, bribery, and personification at election. Personation at election. Personation matlab influencing someone during election. Okay, these are the disqualified under RP 1951. Section 8 clause 1 says that enmity between two groups, bribery, personification. Okay, section 8 clause 2 says disqualifies members for offences related to hoarding, profiteering, and adultering of foods or drugs. What is hoarding? Hoarding is creating a scarcity to increase profits. अगर दाम मार्केट में सस्ता होगा तो डिमांड ज़्यादा होगा, मतलब मार्केट में अगर स्कैर्सिटी आएगा तो डिमांड ज़्यादा बढ़ेगा तो महंगा हो जाएगा. सो इफ़ यू आर अर्निंग प्रॉफिट्स बाय स्कैर्सिटी फ्रॉम मेथड्स सच एज hoarding and profiteering. What is profiteering? Here scarcity is created, but here scarcity already exists, and you are using such provisions of scarcity to suppress the poor and to gain your own profits. So that is profiteering. And for offences related to hoarding, profiteering, and adulteration of foods or drugs or dowry related offences, they are covered under section 82 and 82 and section 8 clause 3. 8.3 covers about disqualification of convicted persons who are more than 2 years. Who are convicted for more than 2 years, such members are disqualified for further 6 years. Okay, that is mentioned in 8.3. And 8A talks about corrupt practices during elections. Okay, and this is about A. Now let us see A we can discuss again. Promoting enmity between two groups, bribery, personification at election, this is one. And offences related to hoarding, profiteering, adulteration of fruits or drugs, dowry prohibition, offences related to Dowry Prohibition Act. So they come under 2. And person who is convicted for more than 2 years will be disqualified for further 6 years. This is mentioned in 3. And 8A talks about corrupt practices during election. Now let us see further sections. Section 9, disqualification of government servants for 5 years from the date of dismissal for corruption. Disqualification of government servants. Okay, government servants who are basically this article, this section talks about disqualification of government servants for 5 years from the date of dismissal of corruption. Matlab, if government servants are participating for election, they shall be disqualified for further 5 years from the date of dismissal for corruption. And section 9 here talks about disqualification for office of profit under the government. Office of profit under the government. Example, 20 MLAs from Delhi were disqualified on the grounds of office of profit in 2023. So this is section 9A. One talks about government servants, another 9A talks about office of profit under government. 10 talks about office of profit under a government company. Okay, this talks about office of profit under a government company. So this talks about disqualification for office of profit under a government company, section 10. And section 10 here talks about if a candidate fails to lodge election expenses within the time stipulated by the Election Commission of India. In such cases also he or she shall be disqualified. Here it's again mentioned, promoting enmity between two groups, bribery or influence or personation at election. Section A2 clause talks about hoarding, profiteering or adulteration of food or drugs. And he shall be from the date of sentence he shall be disqualified for further 6 months. Okay. No, sorry, 6 months for an offense. So he shall be sentenced for disqualified for at least 6 months for an offense related to Dowry Prohibition Act. And 8.3 talks about person who is convicted for more than 2 years shall be further disqualified for 6 years. And 8 talks about corrupt practices during election. 9 talks about government servants dismissed for corruption. They shall be disqualified for 5 years to contest from the date of dismissal of such corruption. And section 9 talks about disqualification for office of profit under government. 10 talks about disqualification for office of profit under a government company, matlab public sector undertaking. Section 10 here talks about disqualification of a person who fails to lodge an account of his election expenses within the time speculated by the Election Commission of India. So what are the remedies available to such a person? Basically there are 3 remedies available, 4 remedies available. One is he or she can approach the Supreme Court, or one second. She has 4 choices. Appeal to Election Commission of India under section 11. So till here we have discussed 10, 10. Now section 11 talks about remedy available. So he or she can approach Election Commission of India under section 11 and ask for the review petition. या फिर he or she can appeal to Supreme Court or request for a stay on High Court or Supreme Court order, and he or she can request for presidential review. President under exemption circumstances might grant pardoning power. Okay, so let us see some of the examples related to that. If a person appeals to Election Commission of India under section 111, then the aggrieved party might be relieved from disqualification, and similarly the aggrieved party might also be relieved if he or she appeals to Supreme Court under section 1168. Just don't remember this I think it confuses. He or she can appeal to Supreme Court. Okay. Example, as in Hazar Hussain versus Rajiv Gandhi 1985, the election petition by the Hussain was rejected by both High Court and Supreme Court due to lack of evidence. Rajiv Gandhi was disqualified in the election petition was filed in the High Court. However, Rajiv Gandhi appealed in the Supreme Court, and Supreme Court declared that this election petition is void because due to lack of evidence, this petition shall be void. And after that, you have also one more option, which is application for a stay. For example, in Indira Gandhi versus Raj Narayan case of 1973, after High Court's order for stay, Indira Gandhi later appealed to the Supreme Court, which upheld her election. Okay, and similarly, presidential review can be done under certain exemption circumstances. So, what are the reforms needed? So, one reform I need is that this Representation of a People Act must be mandatory. Matlab, it must be legal. So now it is not legal, therefore the provisions are not followed. Because it is not illegal and no one is afraid of violating the provisions of RPA. And next is there must be enhanced transparency. There is no transparency, so we need enhanced transparency, and there must be a compulsory audit report to be submitted after elections by the political parties to the Election Commission. Okay, compulsory audit report. Enhanced transparency is required, and we need to implement a UK model of misreporting. So basically, in UK model of misreporting, it says that if someone misreports the election expenditure, etc., then the authorizing body, whatever it is in the UK, it is going to take immediate strict action and disqualify that member. But whereas in India, does the Election Commission have that much of power? No, it do not have that power. So there must be an independent body which can immediately disqualify the member if he or she false fake information or misreports information. And we also need to bring new reforms. Example, there must be only one candidate for one constituency, and there must be lifetime ban on politicians who have committed serious crimes. Okay, now currently, why do you think there is one candidate, one constituency? No, there is not. So there is a huge demand that there must be one candidate, one constituency, because if a candidate, for example, during double membership, you have noticed that member Rajiv Gandhi, he has won in both the seats of Lok Sabha, then he is going to vacate one seat. Then but this basically erodes public trust. This is a betrayal of public trust, and therefore it is recommended by the Election Commission that bipole election, the expenditure for the bipole election must be bared by the candidate who has contested for from two seats. Okay, matlab Rahul Gandhi must bear the election for the bipole election, because whenever there is a vacancy in the seat of the parliament, whenever it is, so the Election Commission is going to conduct by elections, right? So that expenditure must be borne by the candidate who had vacated the seat. So there are certain other criteria where a member is disqualified under RPA 1951. So the offences which are in the nature of criminal offences, and these disqualifications are only for the convicted and they're not for the accused. And Supreme Court in the Lily Thomas case of 2013, it said that the disqualification automatically starts from the date of conviction. That means, for example, he is disqualified for a sentence of some X period, then beyond X period he is going to have 6 years, and this total disqualification will start from this date, from the date of conviction. A 6-year period can be reduced by the Election Commission by giving a suitable reason. Okay. Now, what are the list of criminal offences? Prohibition of enmity between two groups, bribery, we have seen under which sections they are. Social crimes, Dowry Prohibition Act, Section 8, Clause 2, and corrupt electoral practices, we have seen this in Section 8A. Providing false information in nominated papers, proxy voters, booth capturing. See, nowadays Rahul Gandhi is talking about vote chori. Maybe if it comes under vote chori, Modi government might be disqualified. Okay. So using a state machinery during election. वोट चोरी मतलब एक ही हाउस के अंदर 80 इलेक्टर्स आना और एक ही पार्टी को वोट करना, तो ये हो गया ना वोट चोरी. तो दैट्स ऑल. यूजिंग स्टेट मशीनरी ड्यूरिंग इलेक्शन. So all these things come under corrupt electoral practices, and if he or she is convicted under the following laws: under Unlawful Activities of Prevention Act, or Narcotics Drugs of Prevention Act of 1985, or Prevention of Terrorist Act of 2002, or Places of Worship Act of 1991, or Prevention of Corruption Act of 1988, or Customs Act of 1962, or laws enacted for the prohibition of adulteration of foods and drugs. So under all such acts, the member shall be disqualified if convicted. Okay. And one thing you need to note on is that detention under preventive detention cannot be considered as a disqualification. Okay, preventive detention is not considered as disqualification. There are certain other criteria where a member can be disqualified under RPA 1951, which are not in the nature of crime. So we have discussed about the nature of crime. It is Unlawful Activity Prevention Act, Narcotics Drugs Prevention Act, etc. They are in the nature of crime. So if they are not in the nature of crime, there is no 6-year period after the sentence. So you need not file any false. So what are the offences that are not in the nature of crime? For example, false electoral practices, coming under a government contact, मतलब office of profit under a government, office of profit under a public sector undertaking, etc. So all such things we have seen in 9192, etc. Those are the criteria which are not in the nature of criminal offences, and they do not have an extra 6-year sentence of disqualification after the sentence. Coming back to our constitution, we have finished qualifications, disqualifications, and qualifications. We have just now seen that we have seen the qualification for SC, ST, other seat. In ST also we have seen how is it for Assam and how is it in other autonomous districts other than Assam. In autonomous district of Assam, the member should be from definitely some other autonomous district, whereas in other seats, a member can be from any constituency, but he must be an SC or ST or from etc. So now we have covered everything. We have covered disqualification under RPA. Did we cover disqualification under 10th schedule? Okay. We have only covered A to F provisions. We have not covered disqualifications under 10th schedule, where the decision of the presiding officer, that means the speaker or chairman, is going to be final. So the Parliament has introduced a 52nd Constitutional Amendment Act of 1985 by adding 10th schedule to the Constitution, and it added 102 subclause 2 for the anti-defection law for MPs, and 191 clause 2 for the anti-defection law for some MLA. 102 talks about disqualification, and clause 1 provides A to E wala provisions, and 2 provides disqualification and 10th schedule. This 102 clause 2 is added by 52nd Constitutional Amendment Act of 1985, and the presiding officer, matlab the speaker or the chairman, he or she has been given the complete powers to make rules related to anti-defection law, and any decision related to disqualification of an MP or MLA is taken by the presiding officer. Okay. And his decision shall be final. Now let us see what are the provisions. So if a member voluntarily gives up his political party and joins another political party, then that member is disqualified. If an independent member of the house joins a political party, then also he is disqualified. Why? Because people voted him because he is an independent member. Now he is joining a political party, therefore he must be disqualified. And if a member voluntarily gives up his political party, I think then also he is disqualified. Even if he do not join any political party, the people voted him because he is from some political party, I think then also the member will be disqualified. And if a nominated member of the house joins a political party after 6 months, मतलब nominated member is given a choice to join any political party within 6 months, but if he joins any political party after 6 months, then he will be disqualified. For example, Sachin Tendulkar, if he joins after 6 months, then he will be disqualified. So he need to choose within 6 months. And if a member of a legislative party violates the whip, then after violating the whip, if his party has not forgiven him within 14 days, then such member shall be disqualified. And if less than 2/3 of the members in the legislative party resign, if less than 2/3 of the member, for example, group of members they are resigning from a political party. Let us say group of members are group of members are resigning from a political party, and if these members are less than 2/3, then the entire 2/3 is going to be disqualified. However, if they constitute 2/3, more than 2/3 of a political party are resigning from this particular party and joining any other political party, then they will not be disqualified. Okay. One more thing I would like you to note is that if a speaker or deputy speaker of Lok Sabha or chairman, if a presiding officer resign from a political party, then he will not be disqualified. Why? Because he is a presiding officer. Even if he disqualifies, there is a certain provision that even if the presiding officer disqualifies from the political party, he will still be the presiding officer of the house. Okay, he will not be disqualified because he is maintaining partition now. It's good for the democracy. I would like to discuss some of the case studies about the constitutional validity of anti-defection law. Let us discuss Kyoto Holohan versus Jayachullu 1992. Here the Supreme Court declared that the decision of the presiding officer is final. The Supreme Court held that 52nd Constitutional Amendment Act of 1985 is constitutionally valid. However, 52nd Constitutional Amendment Act puts a restriction on the violation of the power of judicial review, which is invalid. What does this basically? When I'm reading my 52nd Constitutional Amendment Act, I got to know that the decision of the presiding officer, it said that the decision of the presiding officer shall be final and it is not subject to judicial review. Not subject to judicial review, Supreme Court held it as invalid because it is violating the doctrine of basic structure. So Supreme Court held that except the part where it is saying where it is restricting the power of judicial review, other than that the 52nd Constitutional Amendment Act of 1985 is constitutionally valid. This is the judgment of Supreme Court in Kyoto Holohan versus Jayachullu case of 1992. In 2016 there is another case, Nabam Rebia case of 2016, where Supreme Court ruled that the speaker or the presiding officer can't disqualify members if he himself is facing motion of removal pending in the house. If the speaker himself is facing the motion of removal, then he cannot disqualify members. For example, in the state of Arunachal Pradesh, there are certain members in the parliament who were trying to passing motion of impeachment of the speaker, presiding officer, that he is showing certain bias towards a certain other political party. Then what did the speaker do? Speaker, he know that he is going to be impeached, therefore he disqualified all these members under anti-defection law. So Supreme Court said that in the Nabam Rebia case of 2016, Supreme Court ruled that the speaker or the presiding officer can't disqualify members if he himself is facing the motion of removal pending in the houses. So following this, there is a Shiva Sena split case of 2023, where the Shiva Sena party was split into Uddhav Thackeray and Eknath Shinde, and Uddhav Thackeray filed disqualification against the speaker. Then Eknath Shinde filed for a moved the motion of removal for the speaker. Eknath Shinde moved the motion of removal of speaker. So now, using the Nabam Rebia case, Supreme Court already ruled that if a speaker himself he is facing the motion of removal, then he cannot disqualify certain other members. Therefore, Shinde used this Nabam Rebia case and he got some time, and using this time he aligned with the BJP and he formed a new government. And after forming the new government, the new speaker recognized Shinde group as the real Shiva Sena, because now Eknath Shinde is in the majority, and therefore the new speaker recognized Shinde group as the real Shiva Sena. So in the Shiva Sena split case of 2023, Supreme Court ruled that Supreme Court criticized that the misuse of Nabam Rabia case. Supreme Court obviously criticized Nabam Rabia case and said that the Speaker cannot delay disqualification petition of MLAs, because delaying the disqualification petition of MLAs would only lead to escape of the MLAs and would eventually give time to the MLAs to enhance, to change their confidence. So therefore Supreme Court left the Supreme Court therefore left the Nabam Rabia case to a higher bench in future. Now let us, so basically Supreme Court left the Nabam Rabia case for the future benches Now let us see what are the criticisms of anti-defection law. So basically it is not covering the pre-poll or post-poll alliances, it is only covering the alliances so it is basically covering only after alliances are formed, after the polling, after the election is done, after, for example, when did the alliance of the National Democratic Alliance form? After the elections, after the poll. So anti-defection law do not cover such things, and anti-defection law do not cover the pre-poll alliances also. Alliances done before the elections and alliances done after the election, these things are not covered. So it covers it only covers if a member voluntarily gives up his membership, voluntarily gives up his political party, then only such things are being covered under anti-defection law. Similarly, anti-defection law is ineffective in case of smaller regional parties. For example, if a party has only 4 members and the 4 members are joining any other political parties, then it is going to be 100% merger. More than 2/3 of the members are joining any other political party. However, therefore, in such cases where the members are small in a political party, for smaller parties or regional parties, anti-defection law seems to be ineffective. Example, in 2019, 4 TDP MPs of Rajya Sabha merged with BJP. Okay, now next, there is no time limit upon which the speaker can take the decision. Therefore, for example, in the Shiva Sena split, speaker did not take any decision because there is no time limit on him, and eventually the new speaker chose Eknath Shinde as the real Shiva Sena. So this is also one more thing, speaker's role is not neutral. So speaker is from any other political party, so his decision might be biased. So how can his decision can be neutral? Next, by example, in Nabam Rabia case, he disqualified the members who are filing a motion of impeachment against him. And similarly, next, basically a member is disqualified if he has motion of whip against. Basically, a member is disqualified if he violates the whip and violates the whip or order and votes against the direction of a political party. And if his actions are not condoned, then within 14 days, then his political party disqualifies him. His political party appeals to the speaker to disqualify a particular member. So this provision is killing the dissent within the parties. It is not encouraging the diversified opinions. For example, violating the whip even for the legitimate policy differences could also lead to disqualification. So it is killing the diversity of opinions, and it is increasing the dominancy of a dominant person in that political party. And what is the next limitation? Limited scope. It doesn't cover other forms of betrayal or horse trading. What is horse trading? That person is switching the loyalty but is not switching the political party. So it is not covering such kind of betrayals. And next, anti-defection law does not cover the misuse of merger loophole. For example, more than 2/3 of the members can also leave a political party and join another political party. So example, in the Shiva Sena split case, we have seen how Eknath Shinde used the merger loophole. And So if a member voluntarily, it says that if a member voluntarily gives up, then he might be disqualified. But what it doesn't clarify what voluntarily giving up membership from a political party mean. It doesn't clearly say. For example, if I say that a member see for example, a member resigned a member has resigned to for example, if a member resigns to speaker or chairman, if a member resigns to the presiding officer, then he is not considered disqualification, is not considered, it is not considered as defection, because now he is not a member of parliament anymore, because he has already resigned. So after coming out of the parliament, he might now switch political party. And he again can participate in the by-elections conducted by the Election Commission of India, and he again come and contest for the same seat, and even win the election also. So basically the member is not disqualified, but still therefore the anti-defection law do not mention what voluntarily giving up means. And similarly, even if a member is disqualified under anti-defection law, he is not going to be an MP anymore, and still he is eligible for contesting for by-elections, then again he can become the member of the house again. So therefore, disqualification, voluntarily giving up, the voluntarily giving up is not mentioned in the 52nd Constitutional Amendment Act 1985. Okay. So what are the suggestions for reforms for anti-defection law? According to second ARC, the decision of disqualification shall be taken by the president or the governor. Okay, not by the speaker or chairman. Why? Because they might be biased. So as per second ARC, it says that the decision of the disqualification shall be taken by the president or governor on the recommendation of Election Commission of India. And it also says that the Supreme Court in the Kesham Megham Chandra Singh case of 2020 fixed the time limit upon speaker for 3 months. So in Kesham Megham Chandra, it said that within 3 months speaker should take some decision, and his decision shall be filed. Example, in Nabam Rebia case, not in Nabam Rebia, in Shivasena split case, if the speaker had taken a decision within 3 months, he might have not joined BJP, he wouldn't have got time. Okay. So in Kesham Megham Chandra Singh case of 2020, Supreme Court put a time limit of 3 months. Important. And there are certain recommendations of Punchi Commission 2010. It said that there must be, so the decisions must be based upon consensus, and they for example, whatever decisions for the speaker is taking, the decisions, it must, okay, not the speaker, but the decisions within a certain political party, they must be based upon the consensus, not based upon a dominated person in a political party. Because that if the decisions are based upon the common minimum program, then the coalition partners, the opinion of the coalition partners would also be considered, and which would then reduce things such as horse trading, pre-poll election, switching alliances, pre-poll or post-poll elections, horse trading, etc. So all these things wouldn't happen if decisions are based upon consensus, and there should be a common minimum program. This is suggested by Punchi Commission Report 2010. Okay. The disqualified members under anti-defection law should not be allowed to contest election for next 5 to 6 years. And one more recommendation is that the nominated members shall be disqualified whenever they join a political party. Of course, they shall be disqualified, nominated members, immediately. We have put a limit for 6 months, right? But it must be nominated members should also not join any political parties. This is one of the recommendation. There is one more recommendation. For example, in Kesham Megham Chandra Singh versus Speaker of Manipur, it said, the High Court said that Speaker must not have any adjudicatory powers, and the decisions must be taken by an independent authority. Independent authority should decide whether a member is disqualified under defection or not. Okay. So we have covered constitution of parliament, composition of council of states and house of people, what is it? It is 550 maximum, but in actual it is 543. Lok Sabha, it is sorry, this is for Lok Sabha, and yeah, for Rajya Sabha it is 250 and 245. You remember this. And whereas one thing you also need to remember is that all 28 states and 3 union territories participate, whereas here 28 states and 28 states, 4 union, sorry, only 8 union territories participate. 28 states and 8 union territories participate. Okay, readjustment of each census is also seen. And duration of the houses of the parliament, we know that. Qualification for membership of parliament we have read it alongside with the disqualification provisions. And we need to discuss the sessions of the parliament, prorogation or dissolution. I will say you in simple term. So I'll let you know the basic difference. Suppose that this is a session, and the session is going to start and the session is going to end, and this is one more session which might start later. So this can be monsoon session, this can be what is next session after monsoon, maybe winter session, and this session can be a budget session. Let us say this is budget session. So there are 3 sessions usually: budget session, monsoon session and a winter session. And the term period, the gap between each session must be less than 6 months. The gap between each session is called recess. Okay, is called recess. Now one thing you need to remember: president summons a session, and later the president can prorogue a session. So president summons a session and prorogues the session, but a president can sometimes dissolve a session when there is no confidence in the Lok Sabha. So that usually don't happen. The president can summon a session or president can prorogue a session. Okay, this usually happens. Budget session usually happens from the month of February to May. February, March, April, May, for 4 months. This is the longest session because it is happening for 4 months. Whereas monsoon session, it might be from monsoon कब start होती है? July में, July, August, September, of 3 months. And winter session starts from November to December. Okay, and this is winter session. So now I am going to tell you the basic difference between 3 terms. What are the 3 terms? Adjourn. There is a difference between adjourn, prorogue and dissolve. So prorogue and dissolve, they are done by the president under article 85. Just now we are reading about 85 because 84 is about qualification, right? So adjourn, it is done by the presiding officer. So the house is adjourned. So speaker can say the house is adjourned. मतलब आज का sitting खत्म हो गया. It ends the sitting. Adjourn ends the sitting. आज का sitting खत्म हो गया, कल मिलते हैं. The house is adjourned. So there is a difference between adjourn and adjourn signed day. Again, what is adjourn? It ends the sitting for a definite period. For example, the house is adjourned for 2.5 hours. This is a speaker. This is what speaker said. So this means that house is adjourned for a definite time period. But if it is an adjourn signed day, the sitting of the house is ended for an infinite period, and this period of reassembly is not known. So when the speaker announces adjourn signed day, it is an indication for the president to say that the session can now be prorogued, because you know every session has sittings. Day 1, day 2, and day 1 is called 1 sitting, day 2 is called 2 sittings. So every session has sittings. So when speaker announces adjourn signed day in one sitting, then it is an indication for the president to finally prorogue the session. Okay. However, even if the speaker do not announce adjourn signed day, still the president can prorogue a session. For example, if I am taking a sitting of a house, say this is one sitting, this is my first sitting of the house, this is sitting 1 and this is sitting 1. So in first sitting, matlab day 1, so the timing it is going to be from 11 a.m. to 6 p.m. Okay, and from 11 to 12 it is going to be question hour, and 12 to 1 it is 12 to 1 is 0 hour, 12 to 1 is just 0 hour, and 1 to 2 is my break period. खाना वाना खाएंगे, this is break. And from 2 to 6 everyone is going to discuss about discussion on bills, motions, resolutions takes place here from 2 to 6. Okay. Now I think you have understood much better about the sessions of the parliament, 3 sessions, and the what is prorogation and what is resolution. Okay. However, all these things, they are not mentioned in article 85. They are followed as per convention. Remember this. It only says that, this article only says that the president shall from time to time summon a session. President from time to time shall summon each house of the parliament at such a time as he or she may thinks fit, with no more than 3 months, no more than gap of 6 months between each session. It just says that, and all these things are followed by all the namings and all these are the things that we kept. But the article just says that the president shall summon each house of the parliament at such a time as they may think fit, and the gap between each session shall not be less than 6 months. Okay, this is article 85. And what does article 86 talk about? So before article 86, I would like to take some of the conclusions that from article 85, it is very clear that the executive is the one who decides the number of days a legislature can meet. So basically the council of ministers, they are also part of executive. They are on the advice of them. The president is summoning a session. So the executive is the one who is finally deciding the number of days the legislature has to meet in a session. You know what? During 1950s, people used to meet 120. They used to have 120 sittings in a year, 120 sittings. But nowadays it is reduced to 60 to 70 sittings in a year. So for this, there is a recommendation. There are certain recommendations like to improve the number of sittings. We must follow annual calendar. We must also follow annual calendar, just like in England. Maybe they follow annual calendar of sittings. Annual calendar of sittings, just like how it is in England. So according to this, they must definitely follow this schedule, and those sittings must definitely happen. This is nothing but this is the right of the president to address and send messages to the house. Yes, you understood. Next, article 87 says that special address by the parliament. So president can do special address. President usually gives special address when during the commencement after each general election. The president gives his special address, and after the first session of each year. Okay, president gives his special address after first session of each year. Sorry, not after the first session, at the first session. मतलब जैसे कि अब बजट सेशन शुरू होने वाला है, तो पहला प्रेसिडेंट स्पीच शुरू होगा यहाँ पे फर्स्ट सेशन ऑफ ईच ईयर. So president gives his special address. Article 88 talks about rights of the ministers and attorney general as respect to houses. Rights of ministers and attorney general as respects to houses. Okay, what are they? So we are discussing article 88, rights of ministers and attorney general as respects to houses. So it says that every minister and attorney general, who is attorney general or advocate general of the state, okay, attorney general of India, similar to advocate general of state, he is the minister, so he is the advocate or a lawyer of on behalf of union government, who supports, who is an advocate on behalf of central government. That's all. So every minister and attorney general shall have the right to speak in and take part in the proceedings of any house. However, it doesn't mean that by virtue he or she shall be entitled to vote. That means, suppose a minister who is a minister MP of Lok Sabha, he cannot vote in Rajya Sabha, and vice versa. Okay, for example, an MP of Rajya Sabha, just because he is a member of Council of Minister, he cannot vote in Lok Sabha. So now let us discuss the articles. We have finished all the articles till 88, starting from 79. Now let us discuss the officers of the parliament 89 to 98. So who are the presiding officers? In Lok Sabha, the presiding officers are speakers, deputy speakers, and panel of chairmans. In Rajya Sabha, the presiding officers are chairman, deputy chairman, and a panel of vice chairmans. So who are these panel of chairmans and vice chairmans? I know about them, but I am listening them for the first time. So basically, the provision for the speaker and deputy speaker, chairman, deputy chairman, they are mentioned in the constitution. The panel of chairpersons, the panel of vice chairpersons in the Rajya Sabha, panel of chairpersons in the Lok Sabha, it is not mentioned in the constitution. It is mentioned in the rules of Lok Sabha. Similarly, panel of vice chairpersons, it is mentioned in the rules of Rajya Sabha. Okay, and the panel of chairpersons is appointed by the speaker, whereas the panel of vice chairpersons is appointed by the chairman. One more thing you need to note is that the term deputy doesn't imply that this person is subordinate to him. This just implies that the functions of chairman shall be functioned by the deputy chairman in case of any vacancy, okay, or in case of any absency. So before, in the beginning of our session, we have discussed that article 80, 90, 91, 92 talk about Rajya Sabha, that means they talk about chairman and deputy chairman. 93 to 96 talk about speaker or deputy speaker, that means about Lok Sabha. And we have also seen that 97 is talking about salaries and allowances of the presiding officers, and 98 is talking about secretariat of the parliament. Now let us see all these all the articles. But before proceeding, you need to have a clarity between between speaker, deputy speaker, chairman, and deputy chairman. My first question: are they member of the house? Is he a member of the house? Speaker, yes, he is member of the house. Before proceeding to that, let us discuss some of the important facts. First, as per the rules of Lok Sabha, the date of election of the speaker is decided by the president. See, basically, speaker, he is elected. He is a member of the house. Whereas when it comes to chairman, he is not a member of the house. He is directly the vice president. So as per the rules of Lok Sabha, speaker and speaker and deputy speaker, they must be elected. Elections must be conducted, and usually the speaker is, as per convention, he is from a ruling party or coalition party, and the deputy speaker, he is from opposition party. Okay, and the date of election of speaker is decided by the president, and the date of election for the deputy speaker is decided by the speaker. Okay, and this question is asked in UPSC 2022 that as mentioned in the constitution, speaker comes from the ruling party and deputy speaker from the opposition. That's wrong, because it is not mentioned in the constitution. It is just a convention. Also, you know that who are the presiding officers of Lok Sabha? Speaker, deputy speaker, and a panel of chairpersons. So this panel of chairpersons or vice chairpersons, they are appointed from different political party in proportion to their strength in the house. Okay, for example, this is a panel, and all, so that there is a equal representation, and accordingly the panel is represented from different political parties. Now let us discuss this. Is he a member of house? Speaker, yes, he is elected from the members of the house, and the president decides the date of election of speaker. And is the deputy speaker elected? Yes, the speaker announces the date of election of the speaker decides the date of election of deputy speaker. Okay, and what about chairman? Is he a member of the house? No, he is the vice president of India. What about a deputy chairman? Is he a member of the house? Yes, he is also elected from the house. Okay, and tell me one thing, did they take oath? Is it mentioned, the oath of format in the constitution? Is it mentioned, oath of format of the? No, it is not mentioned. Why? Because they have already taken vote as MP. So they have already taken vote as an MP. So why would they take vote as a speaker, deputy speaker, chairman, deputy chairman? No one takes vote, because all of them are MPs. One more thing, chairman, he is not an MP, but he has taken vote as vice president. Okay, next question. Who elected this presiding officers? Members of the Lok Sabha, they elect the speaker, and members of the Lok Sabha also elect deputy speaker. Who elects deputy chairman? Members of Rajya Sabha. What about chairman? What about vice president? Who elect him? So you know how the elections for the vice president are conducted, right? They are elected by Lok Sabha and Rajya Sabha. The chairman is elected by Lok Sabha and Rajya Sabha. So the vice president is elected by the Lok Sabha and Rajya Sabha together, not just the Lok Sabha, not just the Rajya Sabha. Okay. And how is the seat vacated? So the vacation of the seats for chairman and deputy chairman, you know, right? So you know that 89, 90, 91, 92 they talk about Rajya Sabha, 92, 93, 94, 95 they talk about Lok Sabha. So the articles, so basically the first 4 articles are about Rajya Sabha, next 4 are about Lok Sabha, and 97 is about salaries and allowances of presiding officer, 98 is about the secretariat of parliament. So the article 90 and 94 they talk about the vacation of the seat. Article 90 talk about the vacation of the seat of presiding officers of Rajya Sabha. 94 talks about vacation of seat of the presiding officers of Lok Sabha. Okay, 90 and 94. You're clear with them. And removal. How are they removed? How is the presiding officer removed? So let us see about chairman. Basically chairman is the okay. Let us see for the normal people. See speaker and deputy speaker. How are they removed? They are removed by effective majority. And the deputy chairman also he is removed by effective majority. However, the chairman he must be removed as a vice president. So removed as vice president. So whatever procedure is followed for the removal of vice president, that the same thing shall be followed for the chairman. Matlab he is removed as a vice president, so a new vice president must come. So for this Rajya Sabha must have effective majority, whereas Lok Sabha must have simple majority. Okay. And what is the term period? Term period for speaker or speaker, deputy speaker is 5 years, whereas the term period for MP is going to be 6 years. MP of deputy chairman is going to be 6 years because he is an MP of Rajya Sabha. But whereas the term period of vice president is just 5 years, right? Because the government is going to stay for 5 years and he is a part of executive of the current government. Therefore, the term period of vice president is also 5 years. That means the term period of the chairman of the Rajya Sabha is also 5 years. There is one exemption to this. Key term period is definitely 5 years. However, the speaker stays in the office until immediately a newly constituted house. Until immediately of the newly constituted house. For example, 5 years is over, everyone left the house, but still the speaker will still be there until a newly constituted house assembles. Till then he will stay in the office. So now let us discuss about the chairman and deputy chairman. It says that chairman is who is the chairman? Is the president of India. That article is already discussed in the vice president. Now we are discussing about vice president. So vice president is the ex officio chairman of the Council of States. Okay, it is again restated here. Vice president is ex officio chairman of Rajya Sabha and Council of States. And 89 clause 2 says that the Council of States shall this article says that the Council of States shall choose a member of council to be a deputy chairman. That means a deputy chairman is going to be some member of the Council of States. Okay, if the seat of the deputy chairman becomes vacant, then the council shall choose another person who can become the deputy chairman. So unlike vice president, who is the chairman of Rajya Sabha, where the elections need to be conducted, that is not the same case in case of speaker. Okay, I mean, see, for example, chairman, deputy chairman. So if there is a vacancy seat in case of chairman, then separate elections need to be conducted. Till then deputy chairman will be acting as a chairman, but anyhow elections need to be conducted for the seat of vice president. But if a deputy chairman if the seat of deputy chairman becomes vacant, another elections, someone will be chosen from the opposing party, because you know, right, he is going to be from the ruling party, and this person is going to be from the opposing party. So someone from the opposition party will be chosen. Chosen matlab usually that is the convention followed, however elections takes place. Okay, so now I am saying that the vice president is ex officio chairman of Rajya Sabha, and the deputy chairman will be chosen from elections. Okay, and this is article 89. Article 90 talks about vacation and resignation. So the seat will be deemed to be vacant if there is a vacancy in the office, if he ceases to be member of council. Matlab, if he is not an MP, then the seat can be vacant, or else what other things are possible? If he resigns from his office, then also seat can be vacant. Yes, and if he or she is removed, he or she is removed by a resolution passed by the majority and all the then members. All the then members मतलब effective majority, अगर effective majority से पास होती है and वो impeach हो जाता है, तब भी seat vacant हो जाएगी. So such a motion of removal, for such a motion of removal, the speaker must be sorry, not the speaker, here we are talking about the chairman, remember that. So the chairman, a notice must be sent to the chairman at least in 14 days prior. Okay, so we are here talking only about the deputy chairman, not about the chairman, because chairman is the vice president of India. There is some other provision that we have already studied in the union executive. So here we are only talking about the deputy chairman. So the seat of the deputy chairman shall be vacant if he ceased to be a member of Rajya Sabha, or else if he resigned from his office to the chairman, or else if he is removed by an impeachment by the Rajya Sabha, that is by effective majority. So this impeachment, for such an impeachment to be passed by the Rajya Sabha, at least a 14 days prior notice must be sent to the deputy chairman. Now let us discuss about article 91. It says that the power of the deputy chairman with respect to powers of the deputy chairman to perform the duties of the office or to act as a chairman. So basically it talks about if chairman seat is vacant, who is going to fill the seat? It is going to be filled by the deputy chairman. And if the seat of the chairman is again vacant, then who is going to fill the seat? So in such a case, the president may appoint anyone. The president determines who must be the chairman for the time being. Okay, matlab if the seat of the chairman is vacant, vacancy can be due to many reasons. One reason is he might be acting as a president currently. So there are many reasons. However, if the chairman seat is vacant, this is talking about vacant. Clause 1 talks about vacant. If the chairman seat is vacant, then the deputy chairman acts as a chairman, and but even if the deputy chairman seat is vacant, the president may determine whom to appoint as the acting chairman for the time being. And now what if the chairman seat is not vacant, and what if the chairman seat is absent? So if there is an absence in the chairman seat, then of course deputy chairman is going to be the chairman for the time being. But if deputy chairman is also absent, then rules of the procedure of the council determine, not the president. Okay, in case of absency, rules of the procedure of the council determine, but in case of vacancy, president determines. Okay, and we are discussing article 92 now. The chairman or deputy chairman not to preside while a resolution for his removal from office is under consideration. So they cannot preside during his removal from the office. So while any resolution from the removal of the vice president is under consideration, the chairman or deputy chairman cannot preside. This is the same thing for the speaker or deputy speaker also. You will see in the later articles. Okay, they cannot preside. However, they can take part. The next clause says that the chairman has the right to speak in the proceedings of his impeachment, and he can take part in the proceedings. However, he is not entitled to vote at all. Okay, And for example, nothing withstanding in Article 100. Article 100 talks about the casting vote of chairman in case of equality of votes, but there is no such thing seen, and he cannot vote. Chairman cannot vote during his impeachment. That's all. Now let us discuss about the speaker and the deputy speaker of the Houses of the People. So the speaker and the deputy speaker, they can be any member, any two members. मतलब the Lok Sabha can choose any two members who मतलब the Lok Sabha can elect any two members, and if the seats of these two members who are speaker and deputy speaker, they become vacant, and then the Lok Sabha can choose any other two members who can become the speaker and deputy speaker. Okay, that is the clause 3. Speaker and deputy speaker, they are the members of the parliament, members of the House of the People. And next article says that vacation and resignation of remote. Okay, fine. The seat of speaker or deputy speaker, it shall be deemed to be vacant if he or she ceases to be minister of the House of the People. मतलब he or she ceases to be minister of MP of Lok Sabha. If he or she is not an MP of Lok Sabha, then he or she is not a member of he or she is not a speaker or deputy speaker. So his seat shall be deemed to be vacant. Or else, if he or she resigns his office, for example, if speaker resigns his office to deputy speaker, or deputy speaker resigns office to speaker, then in such cases the seat of speaker or deputy speaker will be vacant. And in another case, if he or she is removed by an impeachment of by a resolution passed by a majority of all the then members matlab effective majority, then in such case the seat shall be deemed to be vacant. But however, such motion of removal must be there matlab a prior notice of before 40, a prior notice of at least 14 days must be sent to the speaker or deputy speaker before taking such action. And before taking the motion of impeachment, a prior notice of at least 14 days must be sent to the speaker or deputy speaker. Now we are clear with vacation and resignation for the removal of deputy speaker and speaker. One thing you need to note is that whenever the House of the People is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the House of the People. For example, say the House is dissolved, but the speaker will still be there until a new House is constituted. Until the first meeting of the House is constituted, the speaker will not resign. Okay. मतलब स्पीकर शैल नॉट वेकेट द ऑफिस, दैट इज़ द रूल कि स्पीकर ऐसे रिज़ाइन नहीं कर सकता. एंड वेकेंसी कब होती है? अगर वो MP ऑफ ही इज़ डिस्क्वालीफाइड फ्रॉम बीइंग MP ऑफ लोक सभा, or else he resigned his office to deputy speaker, or deputy speaker resigned his office to speaker, or else he is impeached by all the then members effective majority. So next article talks about talks about what if the next article says that what if office of speaker is vacant. If office of speaker is vacant, then the deputy speaker is going to perform the duties of speaker. But what if if the office of deputy speaker is also vacant, then the president may appoint someone. So the president may appoint so the president determines who can be the speaker. So similar to the Rajya Sabha, where if the office of chairman and deputy chairman is vacant, then the president determines. But in case of vacancy, there also we have seen what if the speaker is absent. So if the speaker is absent, and then a deputy speaker takes in charge. But if deputy speaker is also absent, then the rules of procedure of the House determine who shall be the speaker of the House for today's session. Okay, I think generally they are chosen from the panel of chairpersons or panel of vice chairpersons. They are chosen panel of chairpersons for Rajya Sabha and panel of vice chairpersons for the panel of chairpersons for Lok Sabha, panel of vice chairpersons for Rajya Sabha, I think. Yeah. And the next article is important. The speaker or deputy speaker not to preside while his resolution is taking place. As you have seen, in case of chairman, during his resolution of removal, the chairman can take part. Chairman cannot preside the house. That was sure. Similarly, here also the speaker or deputy speaker, whoever is presiding, he or she cannot preside. That is one thing. And in such cases, whatever rules are applying for in case of absences under the rules of procedure of the house, that person is going to preside the house. Similarly, in the case of a chairman also, someone from the rules of procedure, that person is going to preside the house. And after that, uh, there are certain provisions still, despite his despite his motion of removal, a resolution for removal, he can still take part in the proceedings, and he or she shall have the right to speak. However, he or she is entitled to vote only in the first instance and cannot vote in the case of equality of votes. I'll explain you clearly. For example, this is our chairman, this is our speaker. So in case of chairman, if he or she doesn't preside the house, he or she is not going to be the member of house in the parliament. Whereas if speaker do not preside the house, then he is going to sit as an MP in the house. So that's the difference. That is why in case of chairman, if he or she do not preside the house during his resolution for removal, he cannot take place in the voting. So मतलब चेयरमैन खुद की रिमूवल में वोटिंग नहीं कर सकता, लेकिन स्पीकर खुद की रिमूवल में वोटिंग कर सकता है. दैट मीन्स बिकॉज व्हेन द स्पीकर do not preside, then some other new speaker, as determined by the rules of procedure in the Lok Sabha, matlab new speaker presides. So there is a new speaker already, so this speaker is going to sit as an MP and he is going to vote for his own impeachment. So yes, speaker can vote for his own impeachment in his first instance, but he cannot vote in the second instance. Second instance matlab during equality of votes. During equality of votes, speaker cannot participate in the resolution for removal from his office. So that is the difference between chairman and speaker during the resolution of removal from his or her office. Okay, so we have finished all the articles. See, we have finished the articles from 89 to 92, chairman and deputy chairman of council of states. The article mainly talks about it talks about chairman, who is going to be the ex officio chairman of Rajya Sabha, that is the vice president is going to be the ex officio chairman of Rajya Sabha. And it also talks about deputy chairman. Deputy chairman, he is chosen from members from the council of states. And it also we have also seen article 90, which talks about vacation of the seat. If he or she is not an MP of Rajya Sabha, then the seat will be vacant. Or if he or she resigns to the, actually this article 90 talks about deputy chairman, it doesn't talk about the chairman. So because we know that vice president resigns to the president, so it says that if deputy chairman resigns to the chairman, and then his seat shall be deemed to be vacant, and or else his seat can be vacant if he is impeached by the parliament by effective majority. So in such cases his seat will be vacant. This is article 90. So article 91, it talks about power of the deputy chairman to act as a chairman. That means it says if the seat of the chairman is vacant, then it can be filled by deputy chairman. However, if the deputy chairman seat is also vacant, then president will determine who can be the chairman. So similarly, if the seat of the chairman is vacant due to absency, then a deputy chairman will take. But if deputy chairman is also absent, then rules of procedure of Rajya Sabha determine. Okay, this is article 92. This is article 91. So we have finished 80, 90, 91, and we have checked 92. 92 says that the chairman or the deputy chairman not to preside. So it speaks about not to preside. So during his resolution for his removal from office, the chairman or deputy chairman, they cannot preside. Therefore, but they can still take part in the proceedings, and they have the right to speak, but they do not have the right to vote. Okay, this is article 92. And we have also seen article 93. This is similar to the provisions like chairman and deputy chairman, but here speaker and deputy speaker, they are any two people can be chosen from the house of the people through elections. Okay, and 94, vacation and resignation. It talks about vacation and resignation and removal from the office of the speaker and deputy speaker. They are also the same provisions like if he or she is not an MP of Lok Sabha, if he or she, well, if speaker resigns to deputy speaker or deputy speaker resigns to speaker, then the seat will be vacant, resign. And the next thing is, if a speaker or deputy speaker are impeached by the Lok Sabha by then effective majority. So one thing you need to remember here and there, that and prior notice of 14 days must be sent to the speaker or deputy speaker, chairman or deputy chairman before such motion of removal. Okay. We have seen vacation of the seats, power of the deputy speaker in case. Okay, so here when when speaker is absent, deputy speaker can become the speaker. However, if the deputy speaker is also absent, then the president determines who can be the new speaker. Similarly, if in case if the speaker, instead of a vacancy, if speaker is absent, then deputy speaker deputy speaker acts as the speaker. But if deputy speaker is also absent, then the rules of procedures of Lok Sabha determined. Okay, yeah. And we have also seen that the speaker and deputy speaker, they do not preside while resolution for his or own, similar to the chairman or the deputy chairman, where they cannot preside during their motion of removal. Similarly, they can also not preside. However, here there is a interesting fact that if a speaker do not preside, then he is going to become the MP of Lok Sabha. Matlab, he is going to become the member. Unlike chairman, where he cannot be the member. So here, since he is a member, he can take part in the votings. Therefore, speaker can vote in first instance, whereas chairman could never vote. And but in case of equality of votes, that is second instance, the speaker cannot vote. So we have discussed this. Article 96 is over. And coming to salaries and allowances of chairman and deputy chairman, for this parliament by law can determine. If parliament by law do not pass any law, then they are provided as per second schedule. Second schedule talks about emoluments. But anyhow, parliament has passed a law. It's the Salaries and Allowances of Officers of Parliament Act of 1953. Okay, as per this act, the salaries and allowances of the speaker or deputy speaker are determined, or chairman or deputy chairman or deputy of the presiding officers are determined by the salaries and allowances of officers of Parliament Act of 1953. Now let us see the powers of the Secretariat of the Parliament. Okay, so now we are seeing the okay, what is the power of a Secretary General, by the way? So he is the administrative head of the Secretariat in each house, and he is in charge of the administrative and executive functions on behalf of speaker or chairman. And this person, Secretary General, is the highest ranking IAS officer. He is not connected with the politics. And his appointment, speaker or chairman choose someone among who served parliament for many years as a secretariat. And there see, this is Lok Sabha, this is Rajya Sabha, and each house has to separate secretariats. Okay, term and tenure, they remain secretariat from their appointment till the age of retirement. And what are the conditions of office? Of course, he is the highest ranking civil servant of union government, and his actions of Secretary General cannot be discussed or criticized outside the house, and is answerable only to the speaker or chairman, and his actions are not criticized inside or outside the house. Okay, so that means you can imagine his power. And what are the powers and duties of secretariat? The Secretary General of Lok Sabha, he is advisor to the speaker, or Secretary General of Rajya Sabha, he is advisor to the chairman, and he is also advisor to house members on parliamentary functions, members of procedure and practice. He is a permanent member, linking changing composition of houses and the speaker of the chairman. These people, they get changed, but IAS officer, he remain there. So he is the permanent officer, linking changing of houses and the changing composition of houses and the speaker and chairman. Okay. He keeps all the parliamentary records, and that is how he is able to connect changing composition of houses and speaker and chairman. And he issues summons on the behalf of president to attend the sessions of the house. You usually say the president summons the session. It is president summons the session, but on behalf of President, Cabinet Secretariat is the one who summons the session on behalf of President and assumes the office of Secretariat of all parliamentary committees. Okay, he also assumes the office of Secretary of all parliamentary committees under the respective houses. And also he is conventionally appointed as a returning officer whenever elections are conducted. He is also conventionally appointed as a returning officer. So as per Article 98, each house of parliament shall have a separate secretariat staff, provided that nothing in this clause shall be construed by as a preventing the creation of posts. No, it's not like that. Each of the Article 98 says that each house of the parliament shall have a separate secretariat staff. So Parliament may by law regulate the recruitment and the conditions of the service of persons appointed to the secretariat staff. I think in the secretariat staff there are many people, and head of the secretariat staff is the cabinet secretary, and each house of the parliament has a secretarial staff. Okay, now let us look into the conduct of the business of the parliament. Article 99 says talks about the oath or affirmation by the members. So it is each member of the parliament before taking the seat may make and subscribe before the president or some person appointed on behalf of him. So according to the form set out in the purpose of third schedule. So Article 99 do not give any form. The format of oath or affirmation is provided in the third schedule, and it is taken in the presence of president or any person appointed on his behalf. Okay, what does Article 100 say? Okay, so don't get confused. During the impeachment, we have seen that the chairman do not have the voting power during both first instance and second instance, whereas the speaker had definitely had voting powers during first instance, but in case of equality of votes, the speaker do not have a casting vote. In case of speaker, the current speaker who is presiding Lok Sabha comes and cast his or her own vote. Okay, now we are going to see a different thing. We are going to discuss voting in houses, power of houses to act notwithstanding vacancies and quorum. Okay, all questions at any sitting of either house or joint sitting of the houses are save as otherwise provided. All okay, it says that the matters at any sitting of either house or joint sitting the matters at any sitting of either house or joint sitting shall be determined by a majority, which majority shall be determined by a simple majority, excluding speaker or chairman, who shall have a casting vote in case of equality of votes. Okay, all the matters, whether it is separate or joint sitting, they shall be voted by simple majority only, except save as otherwise provided in the constitution. Matlab, otherwise provided in the constitution, for the rest of everything we are assuming simple majority. And we are also going to see that the chairman or the speaker shall not vote in the first instance, but they have a casting vote in the second instance. So Article 100 clause 1 talks about casting vote. It talks about simple majority and it talks about the casting vote. Okay, it says that both chairman and the speaker, they have casting vote. Okay, this is very different from impeachment. In case of impeachment, both the speaker and chairman, they do not have casting vote, but a speaker can vote in first instance, chairman cannot vote in the first instance. And next, neither house of the parliament shall have the power to act notwithstanding any vacancy. So what Article 100 clause 2 say? It says that the house can function even if there are vacancies in their membership. The house can function even if there are vacancies in the membership, and the proceedings are valid even if it's later discovered that someone who shouldn't have participated did so. So if it is discovered that someone who should not participate have participated, फिर भी the proceedings in the parliament, they are not declared invalid just because of vacancy or just because someone who shouldn't have participated in the voting. So due to those reasons, the proceedings of the parliament will not be declared invalid. So this is clause 2. So it just says that notwithstanding vacancies. It talks about notwithstanding vacancies. Notwithstanding vacancies, the proceedings in the parliament are not declared invalid. So article, you are clear with 1 to article 1 talks about casting vote. It also says that otherwise provided in the constitution, all the articles, all the majority of votes are considered are determined by simple majority. And article 100 clause 2 says that notwithstanding vacancies, all proceedings in the parliament shall be declared valid. And article 100 clause 3 gives provision about quorum. It says that 1/10 of the total members of unless there is 1/10 of the total strength, that is 1/10 of 543 55, unless there is 1/10 of the total strength, I am calculating it for Lok Sabha, for example. You can calculate it for Rajya Sabha also. So and unless till there is 1/10 of the total strength, it shall be the duty of the article quorum. Okay, article 100 clause 3 talks about 1/10 of total strength, that is the quorum. And article 100 clause 4 says that until quorum is achieved, it shall be the duty of the chairman or speaker to adjourn the house or suspend the house until there is a quorum. Okay, it shall be the duty of a speaker or chairman to adjourn the house until quorum is achieved. Okay, speaker or chairman. So we have finished conduct of the business, oath or affirmation by the members. It is taken in presence of a president, and the form of oath is mentioned in the 3rd schedule. And voting in the houses, power of the houses notwithstanding vacancies. And so voting in the houses, it is done through simple majority. We have seen. Power of the houses to act notwithstanding vacancies. Notwithstanding vacancies, फिर भी proceedings are valid. And we have seen that quorum at the 1/10 of the total strength, and until there is 1/10 of the total strength, it shall be the duty of it shall be the duty of whom? It shall be the duty of speaker or chairman to adjourn the house or suspend the house until the quorum is met. Okay, we have also seen disqualification provisions along with article 84. Now let us discuss the power, privileges and immunities of parliament and its members. So we shall discuss power, privileges, etc. of houses of the parliament, and it is very simple. And we shall also see what are the salaries and allowances of members. It just says parliament by law, and we have salaries, allowances and pensions of members of parliament act of 1954. Okay, so now let us see article 105. So this article basically says that everyone has the freedom of speech. No member of the parliament shall be liable to any proceedings in the court of law, etc. My notes is better, so let us see here. MPs have absolute freedom of, so what are the powers, privileges of the members of parliament? Members of parliament have absolute freedom of speech in the parliament, subject to rules of procedure, and no court can question anything that is said in the house. And they have legal immunity for speeches, discussion and votes in the parliament or committees. Parliament can define its privileges by law, but until it is defined, it shall enjoy the same privileges as that of the British used to be before, that is House of Commons, on the date of commencement of the Constitution. Okay, and every non-MP participant, example Attorney General of India, who is not a member of parliament, he shall have the right to speak in the parliament, and he is also granted the same immunities as the immunities granted to the member of parliament. Okay, so now let us discuss the legislative procedure. Article 107 to 111. 107 talks about provisions as to introduction and passing of bills. Here you are going to see what happens if during the dissolution of bills, when the bill is introduced in Lok Sabha and pending in Rajya Sabha, etc. So and article 108 talks about joint sitting of both houses in certain cases. For example, when president summons joint sitting, and under what bills are not subjected to joint sitting, all such things are discussed under article 108. And Article 109 and 110 we are going to discuss about money bills, and Article 111 you already know, it talks about the veto powers of the president assent to bills. Okay. Instead of going to the constitution, I would like to directly go through my notes. So provisions as to introduction and passing of bills. A bill can be introduced either in Lok Sabha or Rajya Sabha except money bills and financial bills, because they can be introduced only in Lok Sabha. This is mentioned in Article 107 clause 1 that a bill can be introduced either in Lok Sabha and Rajya Sabha except money bills and financial bills, which can be introduced only in Lok Sabha. And 107 clause 2 says that a bill is placed only when both houses agree, except for Articles 108 and 109. Okay, a bill is passed only when both the houses agree, except for 108. मतलब एक्सेप्ट ड्यूरिंग 108, मतलब अगर एक हाउस एग्री नहीं होती है तो यूजुअली बिल पास नहीं होती है. बट जॉइंट सिटिंग के टाइम पे अगर एक हाउस एग्री नहीं करती है तो जॉइंट सिटिंग समन किया जाता है. दिस इज स्पेशली ड्यूरिंग ऑर्डिनरी bills and financial bills. And also Article 109 talks about money bills. मतलब if during money bills also, if one house rejects, then the bill is not going to be passed. But whereas in all other cases, one house मतलब if one house passes but one house rejects, then there is going to be joint sitting. So usual case, a bill is passed. In usual cases, a bill is passed only when both the houses agree. See, I can see that I have only 4 types of bill basically: money bill, financial bill, ordinary bill, money bill, okay, money bill, ordinary bill, financial bill, and constitutional amendment bill. See, money bill, legislative, Lok Sabha has overriding powers, therefore this clause 2 का कोई सीन नहीं है. और in case of ordinary bills, in case of ordinary and financial bills, there is a provision of joint sitting. Therefore this doesn't apply to this. Only in case of constitutional bills, when a bill is passed only when both the houses agree. So that means when suppose there is a constitutional amendment bill, Lok Sabha accepted but Rajya Sabha rejected, then the bill is not going to be passed as per Article 107 clause 2. Okay, a bill is pending in parliament. A bill pending in the parliament shall not lapse upon prorogation. For example, there is a session and president has prorogued the house. Just because president prorogued the house, that doesn't mean the bill will lapse. Okay, but notices, there are bills and notices lapse, but bills do not lapse after prorogation. Now let us see the effect of dissolution on bills. Article 107 talks about effect of dissolution. Effect of dissolution of bill. So introduction in Lok Sabha, pending in Lok Sabha. If a bill is introduced in Lok Sabha and pending in Lok Sabha, then the bill will lapse. See, the trick is that whatever bills are pending in Lok Sabha, they are definitely going to lapse, because Lok Sabha का decision हमें अभी चाहिए ही नहीं, क्योंकि ये dissolution हो चुका है. तो that is why the bills pending in Lok Sabha are they are definitely going to lapse. But see it here, the bill is passed by the Lok Sabha and now it is pending in Rajya Sabha. अब हम राज्य सभा को ये बोलेंगे कि पास मत किया करो, क्योंकि ये डिसॉल्व हो चुका है, and that is the reason why the bill passed by the Lok Sabha and pending in the Rajya Sabha also lapse. But what if a bill is introduced in Rajya Sabha and pending in Rajya Sabha? अभी तक लोकसभा के पास गया ही नहीं, लोकसभा में पेंडिंग होने के लिए तो गया ही नहीं है, तो दिस विल नॉट लैप्स. सो इंट्रोड्यूस्ड इन राज्यसभा एंड पेंडिंग इन राज्यसभा, दैट इज़ नॉट गोइंग टू लैप्स. सिमिलरली द रेस्ट ऑफ द बिल्स आर ऑल्सो नॉट गोइंग टू लैप्स. For example, if it is pending with the president, Lok Sabha has passed, Rajya Sabha has passed, now it is pending with the president. So it is pending with the president, whether he gives his assent or not, then such bills are not going to lapse. And returned by the president for reconsideration. So president has returned for reconsideration, then such bills are also not going to lapse, because the newly constituted house is going to review it again. If a joint sitting has been notified by the president before dissolution, such bills are also not going to lapse, because the president has issued joint sitting and everything got over already. It is just that a president issued joint sitting. Now we have discussed Article 107, the main important clauses under Article 107. Let us see Article 108. It talks about joint sitting of both houses in certain cases. But before seeing this, let us look into all the four bills once. Okay, these are the types of bills and the process required to pass the bills. Okay, now this article money bills are discussed under article 109 and 110 for center, and 198 and 199 for states. Whereas the provision for the financial bill is given under FINA bills and FINB bills. FINA bills under 117 clause 1, FINB bills under 117 clause 3. Constitution bill, it is under article 368. Not all amendments to the constitution are need constitutional amendment bills. Some bills, certain bills can be amended without requiring constitutional amendment. Certain constitutional amendments can be still done without constitutional amendment bill. Okay, that is about a money bill, ordinary bill, financial bill, and constitutional amendment bill. Constitutional amendment bill. Now let us see the introduction. You already have seen that from article 107 clause 1 that a bill can be introduced either in Lok Sabha or Rajya Sabha except money bills and financial bill. Therefore, money bills and financial bills are only introduced in Lok Sabha, whereas the rest of the bills, they can be introduced either in Lok Sabha or Rajya Sabha. And the next is, do they require prior recommendation of the president? The answer is yes. The money bill and financial bill, they require the prior recommendation of the president, whereas the ordinary bills and constitutional amendment bills, they do not require the prior recommendation of a president. Okay. See, the money bill, financial bill, they are only introduced in Lok Sabha, and the prior recommendation of the president is also required only for money bill and financial bill. And next, what is the majority required for a money bill or ordinary bill to be passed? So all the bills require simple majority. We have seen that if not specified anywhere, the majority is going to be simple. But for constitutional amendment bill, unless mentioned, it is going to be simple majority. But constitutional amendment bill, for constitutional amendment bill, we must have special and absolute majority. Special matlab 2/3 of the members present and voting. Absolute matlab 50% of the total strength of the house. So unless there is special and absolute, the constitutional amendment bill cannot be passed. This is the majority required to pass the bill. Okay, and what are the powers of Rajya Sabha? Powers of Rajya Sabha. See, under money bill, the power of Rajya Sabha that it can only pass, and it has to act within 14 days. If it doesn't act, the bill is deemed to be passed. But in case of ordinary bill, financial bill, and constitutional amendment bill, the Rajya Sabha has three options. It can either pass, it can either reject, or it can either amend. Okay, is deadlock possible in case of bill? Deadlock. Okay. So since Lok Sabha has overriding powers in case of money bills, Lok Sabha has overriding powers in case of money bills, and that is why deadlock is not possible in case of money bills, whereas in case of ordinary bills and financial bills, deadlock is possible. And when deadlock is possible, there is a provision of joint sitting under article 108. Okay. And what about a constitutional amendment bill? Is a deadlock possible? No, there is no deadlock possible, because why? As per why? Because there is no provision of joint sitting. अगर joint sitting का provision नहीं है, मतलब अगर लोक सभा में पास होती है, राज्य सभा में reject होती है, then the bill will not be passed. Okay, there is no provision for joint sitting, therefore the bill will not be passed. Whereas here, in case of money bills, the bill will not be passed, because in case of money bills, the bill will be passed. Despite Rajya Sabha saying a no. See, the same thing here. In case of Lok Sabha, bill will be passed. Bill will still be passed. But here, in case of bill will not be passed, because there is no provision of joint sitting. The provision of joint sitting is only applicable for ordinary bills and financial bills. So what is there joint sitting to remove the deadlock? Yes, as I said, there is a joint sitting to remove deadlock in case of money bills, in case of ordinary bills and financial bills, whereas in case of money bills, there is no provision for joint sitting, and in case of constitutional amendment bills also, there is no provision for joint sitting. Do the president have veto powers? No. If a bill goes from Lok Sabha to Rajya Sabha and then it goes to the president, it is mandatory for the president to give his assent as per convention. As per convention, the president is bound to give his assent for the money bills. And also the president as per 24th Constitutional Amendment Act of 1971, is bound to give assent to constitutional amendment bills because with already 2/3 of the majority, the bill is getting passed from Lok Sabha, and 2/3 of the majority, the bill is getting passed to Rajya Sabha, and now it came to the president. Then that is why the 24th Constitutional Amendment Act of 1971 made such constitutional amendment bill as a binding upon the president to give his assent. Okay. But in case of ordinary bill and financial bill, no, the president has veto powers. Yes, the president can use pocket veto, suspensive veto, or absolute veto, etc. things. But in case of money bills and in case of constitutional amendment bills, the president cannot use his veto powers, and he is bound to give assent as per convention, या फिर as per Constitutional Amendment Act of 1971. Okay. And ratification of states, is ratification of states required? No, ratification of states is not applicable in case of money bills, ordinary bills, and financial bills, whereas ratification of states is possible. Ratification of state is required if center state relations are affected. एग्जाम्पल 101st कॉन्स्टिट्यूशन अमेंडमेंट एक्ट 2016 जीएसटी को लेके आई. 99th कॉन्स्टिट्यूशन अमेंडमेंट एक्ट 2014 में नेशनल जुडिशरी अपॉइंटमेंट कमीशन को लेके आई. तो क्या जीएसटी बाय सेंटर स्टेट रिलेशंस इफेक्ट हो रही है? हाँ, बिल्कुल हो रही है. व्हाट अबाउट नेशनल जुडिशरी अपॉइंटमेंट कमीशन? इसके अंदर कॉम्पोजिशन में स्टेट का जजेस नहीं होंगे. हाँ, सो दैट इज़ वाई मतलब जुडिशरी इज़ अ फेडरल फीचर, राइट? And it is appointing the judges, therefore it is affecting state central relations. So this is the reason why I am saying ki if the central state relations are affected, then the such constitutional amendments also require the ratification by the president, and rest of the cases ये special and absolute से चला जाएगा. And I am zooming out. Money bill, financial bills, money bills, article 109 and 110, article 109 and 110, and financial bills 117, clause 1 and clause 3. Clause 1 talks about FinA bills, which are type of money bills, and FinB bills, which are not a type of money bill. Example for FinA bills are finance bills, that is receipts of a union budget, and constitutional amendment bill, you already know that it is from article 368, and where the money bills are introduced, it is introduced only in Lok Sabha. Money bills and FinA bills are introduced only in Lok Sabha, whereas rest of the bills can be introduced anywhere, and the prior recommendation is definitely required for introducing bill in the Lok Sabha. Okay, yeah, prior recommendation of the president is required. Also, prior recommendation of the president is required except during abolition or reduction of the tax, and also prior recommendation for the ordinary bills is mostly not required except internal reorganization of states, where prior recommendation of the president is required for passing such ordinary bill. Example, internal reorganization of state. Okay, what about the majority to pass the bill? They almost simple majority unless the constitution specifically mentions. For the constitutional amendment bills, we require special and absolute majority. And what are the powers of the Rajya Sabha? Lok Sabha has overriding powers, therefore Rajya Sabha can only pass, whereas Rajya Sabha has all kind of powers in ordinary, financial and constitutional amendment bills. Is there a deadlock possible? No, deadlock is not possible because Lok Sabha has overriding powers. Deadlock is possible? Yes, it is possible in case of deadlock. Is any deadlock possible in case of constitutional amendment bill? No, because there is no provision of joint sitting, because the bill will lapse if even one house rejects. Okay, what about is there joint sitting to remove? Yes, there is joint sitting provision, whereas there is no joint sitting provision for constitutional and money bills. Does president have veto power? No, the president do not have veto power in case of money bill and constitutional amendment bill, because as per convention, president must give assent to money bills, and as per 24th Constitutional Amendment Act 1971, the president is bound to give assent, whereas in case of money, ordinary bills and financial bill, the president can use his veto power, such as absolute, suspensive veto, pocket veto, etc. And ratification of states is not required in case of money, ordinary and financial, whereas ratification is required when the central state relations are affected. Okay, Article 109 talks about special provisions in respect of money bills. It says that Lok Sabha has overriding powers over Rajya Sabha, and Rajya Sabha can send such recommendations within 14 days. So as I already said that we have already seen except in 107 clause 1 also ki the bills can be introduced in only Lok Sabha. Matlab bills can be introduced either in Lok Sabha or Rajya Sabha except money bills and financial bills. We have seen it in Article 107 clause 1. So here also it is similar to that. Article 109 says that, okay, somewhat different, fine. It says that Lok Sabha has overriding powers over Rajya Sabha, and a money bill cannot be introduced in Rajya Sabha. Okay. And assent to the bills. These are the veto powers of the president. If the president gives his assent, it will become a bill will become a law. And the president withholds assent, it is called withhold मतलब रिजेक्ट करना मतलब एब्सोल्यूट वीटो. अगर रिटर्न करेंगे तो वो होगा सस्पेंसिव वीटो. एंड सस्पेंसिव वीटो इज़ यूज्ड ओनली फॉर नॉन मनी बिल्स बिकॉज प्रेसिडेंट कैनॉट यूज सस्पेंसिव वीटो. दैट इज़ वेरी इंपॉर्टेंट. प्रेसिडेंट कैनॉट यूज सस्पेंसिव वीटो फॉर मनी बिल्स. ओके. तो प्रेसिडेंट 6 महीने के लिए सस्पेंसिव तो लगा सकते हैं, बट इफ़ पास्ड अगेन देन इट इज़ बाइंडिंग अपॉन द प्रेसिडेंट टू एक्सेप्ट. मतलब इफ़ पास्ड बाय द पार्लियामेंट, with after 6 months, if passed again by the parliament after 6 months, it is binding upon president to give assent. Okay. But still the president can delay and use suspensive veto. So no action is taken. If no action is taken by the president and is keeping the bill pending for an indefinite period, then it is called pocket veto. So you know that all kind of veto powers already. Let us quickly finish the topic, right? We have already seen provisions as to introduction and passing of the bills, and we have seen the joint sitting in case of joint sitting of both houses in certain cases. Only joint sitting is only possible in case of ordinary and financial. We have seen that. And special provisions with respect to money bills, we have seen that parliament must give his effort. We have seen that parliament, Lok Sabha has overriding powers over Rajya Sabha. We have seen this. And what else? Provisions as to introduction, we have seen when Lok Sabha dissolves, what are the kind of bills that are going to be dissolved, that are going to be lapsed. We have seen all such kind of examples in Article 107. Okay. Now let us discuss procedures in financial matters. Procedures of Parliament in financial matters. Okay. Annual financial statement. What is annual financial statement? It is a budget, and it consists. It has 2 components: receipts and expenditure. Let us see them. But before going to that, we did not check the definition of money bills. This is very important. You can remember it as a TB, tuberculosis, CA, chartered accountants, CAR car. Tuberculosis, chartered accountant, tuberculosis, और tuberculosis and chartered accountant. मतलब चार्टर्ड अकाउंटेंट को ट्यूबरकोलोसिस आ गया, ठीक है. ट्यूबरकोलोसिस, चार्टर्ड अकाउंटेंट, एंड दे आर इन द कार, मतलब ही इज़ इन द कार राइट नाउ. रिमेंबर इट लाइक दैट. सो टी फॉर टैक्स. टैक्स मतलब imposition, abolition, remission, regulation, alteration of the tax. B for borrowings. Regulation of borrowings of Government of India. Regulations of borrowings of Government of India. C for custody out of Consolidated Fund of India or Contingency Fund of India. A for appropriation of money out of Consolidated Fund of India or Contingency Fund of India. And C for charged expenditure. And मतलब कार में C मतलब charged expenditure. So here I am, यहाँ पे C में custody out of Consolidated Fund of India or Contingency Fund of India, and appropriation out of Consolidated Fund of India or Contingency Fund of India. This is custody and this is appropriation from Consolidated or Contingency Fund. So C for charged expenditure, and A and R, audit of accounts of units and states, receipts of money in Consolidated Fund of India and public accounts of India. Okay. So what is the definition of money bill? A bill can be deemed to be a money bill if it contains only provisions dealing with all of them. So see, if any bill is dealing with any of the below 6 clauses, then such bill is termed as a money bill. That's all. So when usually the decision whether a financial bill is a money bill or not, when a financial bill is money bill or not, it is left to the speaker, and as per the decision of the speaker it can be classified as money bill or financial bill. And if it is classified as money bill, then the powers of Lok Sabha are overriding the powers of Rajya Sabha. So mostly to escape या फिर to speed process, sometimes the speaker just classifies the financial bills as money bills so that they can speed process everything. Wait, did we finish everything? Charged expenditure. Actually see, for charged expenditure इसका एक है expansion ये है, charged expenditure, declaring any expenditure as charged expenditure or increasing the amount of such expenditure, whatever charged expenditure का ये. Okay, imposition, once again, imposition, abolition, remission, regulation and alteration of taxes, regulations of borrowings of Government of India, custody out of consolidated fund of India or contingency fund of India, appropriation of money out of consolidated fund of India, contingency fund of India, charged expenditure, मतलब declaring an expenditure as charged expenditure and increasing the amount of such expenditure. Okay, audit of accounts of union and states, receipts of money of in a consolidated fund of India or public account of India. Now let us see financial matters, procedures in financial matters, article 112. So annual financial statement of income and expenditure, this is nothing but, in our local terms, it is budget, and the date of presentation of budget is decided by the president. Okay, and after president decides the date of presentation of budget, and accordingly the bill budget, I will also discuss how the procedure of the budget was followed. Okay, first I am going to discuss the split of the budget. So we are going to divide our budget into receipts and expenditure. Receipts are classified as finance bills, and expenditures are classified under appropriation bills. Okay, मतलब for finance bill we are going to use FinA bills or bills under article 110, मतलब money bills. Okay, whatever bill we are introducing for our receipts, what are receipts? They are inflow. वाटर एक्सपेंडिचर दे आर गोइंग आउट ऑफ गवर्नमेंट. मतलब ऐसे याद रखना कि फिनेंस बिल से मनी अंदर आ रही है और कंसोलिडेट अप्रोप्रिएशन बिल से मनी बाहर जा रही है, ऐसे. सो finance bills and so we have two types of bills, finance bills and appropriation bills. These are expenditure bills, whereas these are receipts. Receipts can be classified into, now let us first see receipts. Okay, receipts can be classified into two, revenue receipts and capital receipts. Revenue receipts are again subclassified into tax receipts and non-tax receipts. Tax receipts again subclassified into direct and indirect, whereas capital receipts, they can be debt creating capital and non-debt creating capital. Which kind of capitals create debt? Example, loans. Okay, capital receipts मतलब देखो कैपिटल से पैसे आ रहे हैं, एक तो लोन ले रही हूँ इसका मतलब मुझे पैसे आया, लोन से पैसे आया इसका मतलब ये नहीं है कि मेरे पास पैसे है, उसको इन फ्यूचर मुझे पे करना पड़ेगा, उसको ही मैं डेप्ट बोलती हूँ. ओके, सो डेप्ट क्रिएटिंग कैपिटल रिसीप्ट्स, एग्जांपल लोन्स एंड बोरोइंग्स. नॉन डेप्ट क्रिएटिंग कैपिटल रिसीप्ट्स, एग्जांपल डिसइन्वेस्टमेंट. Disinvestment, they come under non-debt creating class capital receipt. Recovery, disinvestment, recovery of loans. So when you are recovering loans, you are getting money out of it, right? Because they are paying you back the original amount plus interest, so you are getting profit. That is capital receipt. And you are selling a property, so from that you are gaining some money, that is capital receipt. So they can be debt creating and non-debt creating. Similarly, receipts also have revenue receipts, which can be tax receipt and non-tax receipt. Example for non-tax is rent. Example for tax receipt is income tax and GST. Income is direct and GST is indirect. Now let us see the appropriation bills. So there are two kinds of expenditures under appropriation bill. Expenditures which are charged on consolidation fund of India, expenditures which are voted. So certain expenditures require voting. Such expenditures are called demand for grants. Demand for grants, they require voting, whereas charged expenditure, of course, they do not require voting. So let us see what and all are the expenditures that can be charged upon the consolidated fund of India. But before that, let us see the demand for grants. What are the kind of expenditure bills which require voting? Example, capital expenditure. I want to invest somewhere, so let us vote and decide whether investing in a particular property is giving the government profit or not. So from the investment or revenue expenditure. For example, expenditure for government schemes like Manrega, they classify under revenue expenditure, because Manrega is just a government scheme where we are providing a free subsidy, free jobs to the people, etc. That is why schemes like that, they come under revenue expenditure, and voting is done whether this bill must be passed or not. Capital expenditure, voting is also done for capital expenditure. So capital expenditure and revenue expenditure, they come under demand for grants which require voting, whereas charge expenditure, they do not require voting. So let us see what kind of bills come under charge expenditure. Example, under article 112 clause 3. ओके, आर्टिकल 112 क्लॉज 3 के अंदर ये सब चीज़ें हैं, तो वो सब भी मैंने यहाँ पे छाप दिया. व्हाट आर दिस थिंग्स? सैलरी एंड अलाउंसेस ऑफ प्रेसिडेंट, वाइस प्रेसिडेंट, चेयरमैन, डेप्यूटी चेयरमैन, speaker, deputy speaker, all this salaries and allowances, they are charged upon consolidated fund of India. Salaries of judges of Supreme Court and High Court, they are also charged on consolidated fund of India. Interest payment on the government loans, pensions of retired civil servants, expenses of constitutional bodies like Attorney General of India, या फिर Advocate General of State, Union Public Service Commission. No, I think Advocate General of State का CFI से कट ऑफ होगा, तो अटॉर्नी जनरल ऑफ इंडिया बोलेंगे इसको. यूनियन पब्लिक सर्विस कमीशन, इलेक्शन का कमीशंस का एक्सपेंसेस, ये सब चार्ज होगा कंसोलिडेटेड फंड ऑफ इंडिया के ऊपर. एंड एनी सम्स रिक्वायर्ड टू सेटिस्फाई एनी जजमेंट, डिक्रीज, अवार्ड और एनी कोर्ट और अदर ट्रिब्यूनल. सो एनी अवार्ड्स दैट यू आर गिविंग, सो उसके ऊपर कितना चार्जेस खर्चा लगा, ये सब they are charged on the consolidated fund of India. Any other expenditure declared by parliament by law, they are also charged upon the consolidated fund of India. So I think you are clear. One thing, remember that in the finance bill is classified into receipts and expenditure. Finance bills are classified into receipts and expenditure, and receipts are subclassified into capital receipts and revenue receipts. Similarly, expenditure is also classified into capital expenditure and revenue expenditure, but they come under demand for grants, whereas charged expenditure, they do not require voting, and we have seen examples for that. There are certain important clauses, maybe you can remember. If a money bill is not passed by the Lok Sabha, then the government shall resign. Because if a budget is not passed, then the government shall be resign. Same as if a money bill is not passed by the Lok Sabha, then the government shall resign. And if the speaker certifies under article 110 the bill as a money bill, then that is final. We have already seen a financial bill, if whether a bill is financial or money, the decision upon the speaker is final. The decision made by the speaker is final. And a private member can introduce any of the 5 type of bills except money bill. Who is a private member, by the way? An MP. So any MP can introduce any type of 5 bills. So what are the 5 types of bill we have? We have money bill, or ordinary bill, FinA bill, FinB bill, and a constitutional amendment bill. So there are 5 types of bills, and except for money bill, private member, private matlab who is not a minister, private member matlab not a minister, but he is an MP. So any private member can introduce any of the 5 type of bills. And one more note, all money bills are financial matter bills. You know that all money bills are financial matter bills. For example, we have FinA, FinB, FinA and FinB. Yes, they are all financial. So FinA are money bills. So this says that all money bills are financial matter bills, but not all financial matter bills are money bills. True, right? Not all financial matter bills are money bills. Yes, definitely. Now let us look into the other notes. The constitution doesn't specify the term budget. If the budget is not passed, the government resigns, and the budget is passed by both the houses. However, the demand for grants are voted only in Lok Sabha. Remember this. So when I am discussing this, the this is the demand for grants, and this is voted only in Lok Sabha. Of course, there are receipt expenditure and revenue expenditure, but they come under demand for grants and they are voted only in Lok Sabha. Okay, voting is done, but it is done only in Lok Sabha. Voted only in Lok Sabha. If the budget, in the budget, the details of receipts and expenditure are presented under all three accounts. In the budget, the details of receipts and expenditure, they are presented under all three accounts. Matlab under in a consolidated fund, contingency fund, a public account of India. So for example, we have three accounts. One is consolidated fund of India, a public account of India, contingency fund of India. They are under article 266 and it is under contingency is under article 267, whatever. So here in consolidated fund of India, you mention about revenue expenditure and revenues, matlab receipts and expenditure, matlab finance bills and appropriation bill. Here also you are going to introduce finance bill and appropriation bill in under public account. So here also you are going to show receipts and expenditure. Similarly, here also you are going to show receipts and expenditure. So it is saying that in the budget, the details of receipts and expenditure are presented under all three accounts: consolidated fund of India, contingency fund of India and public account of India. So let us see what they are actually are. Okay, and next, budget under article 112. A budget is a statement of estimated receipts and expenditure presented for a fixed duration of 1 year. Okay. See, the articles 266, 267, 260, like whatever we are discussing now, they are the same for the states also. These are the common articles, and they also have these three columns, and they also show receipts and expenditure under their accounts. Okay, and the article is common for both states and union. Now let us see this. What are the three accounts under the constitution? So it says that consolidated fund of India, basically it includes revenues, loans raised by the treasury bills and repayments of the loans, etc. Whereas a public account of India, it is basically a trustee account of the government, trustee account of the people held by the government. It includes PF deposits, small saving schemes, etc. Whereas when you take contingency fund of India, it is basically it is basically an emergency fund. See, we have an emergency fund of 30,000 crore rupees. So in case a certain amount from the contingency fund is drawn by the parliament, drawn out by the parliament, this expenditure is charged from the consolidated fund of India again, and this 30,000 crore is always maintained in the contingency fund of India. From time to time, several acts have been passed, and finally it has been, the limit for contingency fund of India was increased to 30,000 crore. Okay, and this is utilized for disaster relief, new policy decisions, etc. Okay, consolidated fund of India, it includes revenues of government of India, repayment of loans, etc. And who withdraws? No money can be withdrawn except by authority by law, except by parliament. No money can be withdrawn from consolidated fund of India. And what about contingency fund of India? Finances, okay, contingency fund of India, who withdraws amount from the contingency? Parliament withdraws amount from the consolidated fund of India. Okay, whereas the contingency fund of India, president withdraws. How? Financial secretary on behalf of president withdraws money out of a contingency fund of India. Okay, I think you are clear. See, for contingency it is article 267, and for consolidated fund of India it is 266, and public account is 266. Let us discuss the procedure to enact the budget. So we are discussing the process of budget. You know that what happens usually on 31st January, you know that economic survey will be passed, and next day on 1st February budget will be passed. Okay, budget is going to be passed. So using the application of article 87 that we already know, what is article 87? Joint address of the president. So on 31st January, after the joint address of the president to both the houses, followed by motion of thanks or vote of thanks by the parliament. So when the president gives, addresses both the houses after such address pass motion of thanks or vote of thanks to the president, and after that economic survey prepared by the Department of Economic Affairs, which is a department under Ministry of Finance, which prepared basically Department of Economic Affairs under the Ministry of Finance prepares both economic survey and budget. So this economic survey is tabled before the Parliament on 31st of January, and on 1st February 11 a.m. On the next day, 1st of February, finance minister, example Nirmala Sitharaman, she presents the budget in the Lok Sabha, and she just presents the budget in the Lok Sabha. There is no provision for joint sitting. That means in Rajya Sabha basically a sheet, just a copy of budget is placed on the table, but the budget is presented only in the Lok Sabha and there is no joint sitting. Okay, and after the presenting the budget and after giving her speech, a finance bill is tabled in the house and the house is adjourned for 4 to 5 days. 4 to 5 days मतलब इससे 4 दिन ऐड करेंगे तो 5th फरवरी आ जाएगा. सो 4 दिन तक छुट्टी है. अब 5th फरवरी आ गया. By the way, what is finance bill? Why I am saying that finance bill is tabled and not the budget? Basically, see, budget, economieconomic survey is for the previous year, but budget is for the upcoming year. So in the upcoming year, the receipts, matlab finance bill talks about the receipts, how the government is going to get the receipts, matlab revenue from. So it talks about the tax, matlab kitna, what is the tax, matlab what is the tax rate for middle class, upper class, what is the GST rate, or from where government is planning to get money this year. So all these things, they are under the receipts. So everyone is interested in receipts because that is from where the government can generate money from. And this is expenditure. That means expenditure bill is nothing but appropriation bill where government is going to spend money on. That will be discussed later. For now, Nirmala Sitharaman, after presenting her budget and after giving her speech, a finance bill is tabled and the house is adjourned for 4 to 5 days. And on 5th February, after 4 days, that is the stage 1 of discussion, which we call general discussion. So here, general discussion like what are the taxations and what are the central sponsored scheme, just a general discussion, and no specific details are discussed here. Okay, and on 9th of February, the house is adjourned for 3 to 4 days, and in this period, basically after 5th February, it is 9th February. Okay, I think general discussion takes place for some days, and on the 9th of February, the house is again adjourned for 3 to 4 weeks. And in this period, 3 to 4 weeks is the recess period, right? So in this recess period of 3 to 4 weeks, demand for grants, expenditures are examined, whatever the appropriation bill says. So all the demand for grants are examined by the department related standing committees. So when Nirmala Sitharaman, she has presented her budget, she must have talked about receipts and expenditure, right? So whatever demand for grants are there on behalf of government, they are all examined by the department related standing committees. There are total 24 department related standing committees. Okay, the expenditure charged upon the consolidated fund of India shall be submitted to the parliament and shall be discussed only in the house. Okay, shall be only discussed in the house, इसके ऊपर discussion नहीं होगी, voting नहीं होगी. It shall not be submitted to the board because there are two kinds of expenditure, you already know. One is demand for grants, another is charged upon consolidated fund of India. They will not be subjected to voting, and they will be only discussed, whereas demand for grants, they are examined by the department related standing committees. For now, they are divided into two, revenue expenditure and capital expenditure. We have already seen that. Now let us see after 3 to 4 weeks what happened. So after 3 to 4 weeks, 9th March आ गया. So on the 9th March, that is the stage 2 of our discussion, where detailed discussion takes place. So on the 5th Feb, it was just a general discussion, and on 9th March, after 3 to 4 weeks, it is going to be a detailed discussion in the Lok Sabha on the demand for grants, on the expenditures की voting होगा पार्लियामेंट के अंदर कि कौन कौन से ऊपर हमें खर्चा करना पड़ेगा. These For example, let us say there are one or two bills which require voting. So these one or two are voted one by one in the Lok Sabha. Okay. तो वन और टू बिल्स के ऊपर एक ही दिन में चर्चा थोड़ी होगी. तो that depends upon the speaker of the speaker की the speaker in consultation with the leader of the house. Who is leader of the house? He is the prime minister. So the speaker in consultation with the leader of the house decides the total number to be allocated to such discussions. Usually the total number of days would be 7 to 10 days. So within 7 to 10 days they are going to discuss the demand for grants on 102 bills, and usually 3 to 4, not all bills are voted, some bills are voted and some bills are just skipped. Okay, and we will apply article 113 here. You know what is article 113? So basically this is about everything. Now I am saying that on 9th March there is a detailed discussion on each and every demand for grant, each and every appropriation bill under demand for grant, and such discussion that usually with the consultation of the leader of the house, the speaker fixes the number of days. Usually it is 7 to 10 days, and within 7 to 10 days all the bills must be voted on, or else some important bills can be chosen and they can be voted upon. So before that I would like to discuss article 113, which talks about procedure in the parliament with respect to estimates. That is, demand for grants are voted expenditure, whereas charged upon consolidated they are not subjected to voting, and no demand for grant shall be made except on the recommendation of the president. That means no demand for grant. Suppose Nirmala Sitharaman is introducing demand for grant in the house, but how is she introducing? With the order of the president only. So no demand for grant shall be made except on the recommendation of the president. That means that MPs, they cannot initiate demand for grants. The ruling government is only going to initiate the demand for grants. That means the council of ministers, they advise the president, and with this advice is binding upon the president, and then president issues the order to initiate the demand for grants in the parliament. Okay. That is why I have written application of article 113 on 9th March. And next, but now the speaker has given 7 to 10 days time, 10 days of time. What if the time gets over? So on the last day, the speaker bulletins the discussion for demand for grants and puts the remaining demand for grants for voting. So there are different kinds of motion: bulletin motion, kangaroo motion, etc. So in the bulletin, the rest of them they are just put for voting without discussing them. Usually some of the bills are discussed and then they are put to vote, but if the time doesn't permit, some of the rest of the bills are just put for voting. Okay. The business advisory committee decides the time and order of discussion for each demand for grant. Okay. For each demand for grant, for each appropriation bill, what must be the time allocated? This is decided by the business advisory committee, which is another committee. There are many parliamentary committees. This is one of such parliamentary committees. Okay, now what happened on the 16th of the March? We came from 9th of March to 16th of March now, because the 7 to 10 days got over and all the bills were passed. All the appropriation demand for grants are voted upon. Now, since all the demand for grants are voted, we are going to apply article 114. What does article 114 say? Article 114 talks about appropriation bills. It says that as soon as may be after the grants under article 113 has been made by the House of the People, there shall be introduced a bill to provide appropriation out of consolidated fund of India required to meet the demand for grants. मतलब appropriation bill होगी जो demand for grants को meet करेगी, charged upon so appropriation bill takes care of demand for grants and charged on consolidated fund of India. We know, right? Article 113 appropriation bill, we have classified them into charged expenditure and demand for grants, A, B. Okay. And no amendment shall be proposed to any such bill in either house which will vary the amount, alter the destination of the original of any grant made. So in the bill, if you are introducing say the expenditure is 100 lakhs, then the expenditure is going to be 100 lakhs and this is not going to be increased, this is not going to be varied. Okay, no amendment shall be proposed to any such bill in either house which will vary the amount and alter the destination of any grant so made. मतलब इसका डेस्टिनेशन इंडस्ट्रीज़ के लिए है, लेकिन इसका डेस्टिनेशन भी अल्टर ओके फार्मास्यूटिकल्स में जाना ऐसे नहीं होना चाहिए. एंड द डिसीजन ऑफ द पर्सन प्रिसाइडिंग एज टू वेदर एन अमेंडमेंट इज inadmissible under this clause shall be final. Okay, so you are clear with this. You know that it just says appropriation bill, demand for grants and expenditure upon charged upon Consolidated Fund of India and subjected to provisions under Article 115 and 116. No money shall be withdrawn from Consolidated Fund of India except under appropriation made by law. So 115 is basically an extension. Okay, it talks about Article 115 and 116. Let us see what they are. It is about supplementary, additional or excess grants. Article 115 talks about supplementary, additional or excess grants, and Article 116 talks about vote on account, votes of credit and exceptional grant. What is the difference between them? Okay, first let us see the difference between supplementary, additional or excess grant. Supplementary grant is nothing but extra money for already established expenditure head. So you have expenditure, so you are have extra money for already established, so you are adding some extra expenditure to this. That is called supplementary grant. Extra money for a new expenditure head, that is additional. Okay, extra money for excess money spent in the previous financial year, so excess grant. For excess money spent, okay, extra money for excess money spent in the previous financial year, that is excess grant. And token grant, that is inferred from Article 114 clause 2. So in Article 114 we have seen that 114 clause 2 we have seen that if we want to vary the amount or if we want to alter the destination of the grant made, so it shall not be paid unless the decision of the person presiding as to whether matlab under Article 114 clause 2 it says that usually it cannot be varied, but if you are varying it, then it shall be passed as a token grant. Okay, that is the meaning that I am thinking of. That could have been the meaning of token grant. Okay, so supplementary grant is extra money added to the already established expenditure head. Additional grant is extra money for the new expenditure head. For the new expenditure head, is additional grant, and the already established expenditure head is a supplementary grant, and excess grant is extra money for excess money spent in the previous financial year. For example, in the previous year I have spent 100 lakhs. So now if I am asking some more money for the already extra spent on this, then it is going to be excess, right? So that is excess grant for the already extra money for the excess money spent in the previous financial year, that is expenditure, excess grant. Okay, and a token grant, it is inferred from Article 114 clause 2 where you need to vary the amount or alter the destination of any grant made, token grant. So these are the supplementary, additional or excess grants under Article 115. So now let us see the difference between vote on account, vote of credit and exceptional grants. Parliament may make the following types of grants without the full budget being passed. Okay, sometimes what happens during the election time, maybe Parliament needs to get some money, but it cannot pass the budget. Under certain circumstances, Parliament is going to use vote on account or vote of credit or exceptional grant. What is vote on account? When government needs money to carry on its normal functioning before the full budget is approved. When the government needs money to carry on its normal functioning before the full budget is approved, then the government is going to use vote on account. It is just a temporary funding for 2 months. This is usually passed during elections. Like there is general budget, there is interim budget, and also there is vote on account. So that is the difference. For example, since 2017, it is the demand for the vote on account was drastically reduced because the date of presentation was preponed from February 28 to 29 to February 1st. So in the year of 2017, initially before 2017, the budget used to be presented on end of the February, but after 2017 the budget has been preponed to in the 1st of February. So after such a good change, the entire budget is passed before the 31st March of itself. So see, this is my February, this is my March. So February may pass, like when does your financial year start? It starts from February, no, March to April, right? What is the duration of financial year? Financial year, it is from March 31st to I think no, it's April 1st to March 31st. April 1st to March 31st. So this is my financial year. Now the entire budget is being passed before March 31st. So it means that now the government is having enough money in the consolidated fund of India, and everything got approved before March 31st itself, matlab before my financial year itself, because since the date of proposal for the budget is preponed by 1 month, that means from February 8th to February 1st, government got plenty of time to bring a proper changes and to do proper presentation and to convince the opposition party and to put all the bills for voting. Government got ample amount of time, and that is why there was no requirement for vote on account. See, initially if it had been February 28th, the budget would have been passed by around when April, right? It might have been passed on by March 31st. So March के बाद क्या आएगा? April 31st. It might have been April 31st. There might be 1 month delay or 2 month delay sometimes. So for such 1 month or 2 month delay, we might have required vote on account for such a short period of time. Now there is no requirement for vote on account because everything is proceeding as per time. So that is why the demand for vote on account has been reduced post 2017. Okay, you understood this. This is usually but this is still usually passed during year of elections, where during year of elections the government just proceeds with the interim budget, and it doesn't pass the budget for the entire year, because the government itself do not know what is their term period. So it just passes interim budget for 6 months, etc., and then for extra 2 months, if it requires money, then it is going to pass vote on account. So that is how government is going to use vote on account. So what is vote of credit? Vote of credit is sometimes also called as blank check. Blank check matlab if there is an unforeseen demand and regular budget provisions do not cover it, then we require vote of credit. मतलब अगर कोई सुनामी आ गया, नेचुरल डिजास्टर आ गया, या फिर पाकिस्तान के साथ युद्ध वॉर हो रहा है, तो वी आर गोइंग टू यूज वोट ऑफ क्रेडिट. Next is exceptional grant. If a special need arises which is not included in the annual financial statement, and in such cases we are going to use exceptional grants. If a special need arises which is not included in the annual financial statement, which is not included in the annual financial statement, I am very sorry for being absent minded. So if a special need arises which is not included in our budget, then in such cases we are going to use exceptional grant in case of special need. Okay, now you understood the difference between vote on account, vote of credit, and exceptional grant, which is mentioned in the article 116. Coming to our procedure of budget, we have seen that after 31st January, after a joint address by the President under Article 87 and after motion of thanks by the Parliament, economic survey is tabled by the Department of Economic Affairs, Ministry of Finance, and after that on 1st February, the next day, Finance Minister also presents budget only in the Lok Sabha, and after her speech is over, the House is adjourned for 4 to 5 days, and once the House gathers on the 5th February, a general discussion happens. They are not very specific, and then on 9th, general discussion, it can be for 3 to 4 days, and after that on the 9th of February, demands for grants are examined. Demands for grants are examined by the department related standing committees, whichever department, for example, there is an expenditure bill related to industries, so maybe any department related standing committee related to industries would be examining. So respect to department related standing committees would be examining the department demand for grants, and but you know what, see, the demand the appropriation bill, they consist of demand for grants and charged on Consolidated Fund of India, and they are not subjected to voting, and they are subjected to voting, but for now nothing is taken. And after 3 to 4 weeks after the examination of the department related standing committees, it is around 9th of March, that is the stage 2 of discussion, that is the detailed discussion. We have finished general discussion on 5th of February. Now it is going to be a detailed discussion where each and every bill, for example, there are 1 or 2 demand for grants, 1 or 2 appropriation bills, so each one and one must be voted, and accordingly the speaker decides the time period within which it must be voted. If it is usually 7 to days, and in the last day all the bills are sent to guillotine closure. Okay, now we are on the 16th of March. We are going to apply what Article 114, which talks about appropriation bill. So appropriation bill includes demand for grants and charged upon expenditure, and they are passed on the same day and transmitted to the Rajya Sabha. They are passed on the 16th of March and they are transmitted to the Rajya Sabha. Basically on 16th of March appropriation bill should be passed. Finance bill might be passed on the same day, 16th of March, or on the next day, 17th of March, whichever date it is. So demand appropriation bill is sent to the Lok Sabha and it is transmitted to the Rajya Sabha, and Rajya Sabha, it must act within 14 days. Okay, I think it is not binding upon the Lok Sabha to accept the recommendations of the Rajya Sabha, because money bills Lok Sabha has overriding powers. And coming to the finance bills, finance bills gives effect to the taxation proposals, and accordingly it contains amendment to provisions like Income Tax Act, which might contain provisions to Income Tax Act 1961, Customs Act of 1962. Next, what a Custom Tariff Act. There is difference between Custom Act and Custom Tariff Act. Okay, Custom Tariff Act of 1975 and CGST IGST Act of 2017. So all of them they are going to come under finance bills. Finance bills gives effect to taxation proposals to Government of India, where it contains amendment to IT, Income Tax Act of 1961, Customs Act of 1962, Customs Tariff Act of 1965, CGST IGST 2017. Finance bill gives effect to the taxation proposals to Government of India, where it contains amendment to this. They can be passed upon the same day or on the next day, and which Rajya Sabha has to act upon such a finance bill within 14 days, and which is not binding upon the Lok Sabha to accept it. Okay. Now this is about appropriation bill and finance bill on 16th of March, and before 31st of March both the bills are passed by the houses, and finally they are sent to the president for assent, and the president, when he finally approves, Nirmala, who is our president, Draupadi Murmu, when she finally assents, gives her approval, the budget of the Government of India is successfully passed. Okay, we have already discussed about vote on account. I would like to discuss further. Usually vote of account is granted for 2 months, मतलब अप्रैल एंड मई, फरवरी मार्च के बाद अप्रैल आएगा, मई आएगा. मार्च 31 में क्या होती है, फिनेंशियल ईयर ख़त्म होती है, तो अप्रैल और मई के लिए चाहिए होता है, क्योंकि अभी तक तो बजट पास हुआ नहीं. पहले 2017 के पहले बजट तो पास हुआ नहीं है, तो इसीलिए 2 महीने के लिए चाहिए हुआ होता है. सो यूजुअली ग्रांटेड फॉर 2 months, अप्रैल एंड मई, वेयर 1/6 ऑफ द टोटल बजटरी एक्सपेंडिचर इज सैंक्शनड बाय द पार्लियामेंट. इन द इलेक्शन ईयर वोट ऑन अकाउंट माइट बी टेकन फॉर 4 to 5 months, but in practice the government of day is introducing interim budget only. The government can do 2 things. Either it can use vote on account, which can be for 4 to 5 days, या फिर गवर्नमेंट इंटरिम बजट को ही पास कर सकती है. इतने महीने के लिए कुछ ना कुछ अमाउंट चाहिए. सो वोट ऑन अकाउंट इज अ स्टेटमेंट ऑफ एक्सपेंडिचर, वेयर एज इंटरिम बजट इज अ स्टेटमेंट ऑफ रिसिप्ट्स एंड एक्सपेंडिचर. दिस इज द मेन डिफरेंस. सो वोट ऑन अकाउंट के लिए तुम गवर्नमेंट के ऊपर एक्सपेंडिचर, इतना एक्सपेंडिचर हुआ, सो यू आर चार्जिंग द एक्सपेंडिचर, मतलब या फिर यू आर showing that you are sending demand for grants through vote on account. So this is a statement of expenditure कि इतना expenditure हुआ. But in interim budget you are also passing certain receipts, मतलब you are bringing some changes to tax, मतलब आगे आने वाले 6 महीने का हमारा गवर्नमेंट ही होगी एंड टैक्सेस हम इतना कलेक्ट करने वाले हैं लोगों से, मतलब भारत से हम इतना, भारत की जनता से हम 8% या फिर 15% का टैक्स कलेक्ट करना चाहते हैं आने वाले 6 महीनों में. सो दैट इज़ द स्टेटमेंट ऑफ रिसीप्ट्स एंड that there are also statements of expenditure in the interim budget, whereas vote on account is just the statement of expenditure. So that is the main difference between vote on account and interim budget. The term interim has no correlation with the interim government. No, there is no relation, or the term interim has no correlation with the strength or confidence of the government. It just implies that it is introduced by the government having confidence of Lok Sabha before elections, as the new government shall present the budget or main budget after the election. So that is why we have used the term interim, because so what is interim government? It is that if government loses, usually interim government occurs when there is no government formed at the center which is enjoying the confidence of Lok Sabha. So in such cases interim government can be formed, but that is very different from the term interim used here. So the term interim just implies that it is introduced by the government having confidence of Lok Sabha, because as the new government forms after the election, it shall present the main budget, that is the general budget. Okay, the last article we have covered is 116. So let us see 117 now. 117 talks about special provisions as to finance bill. There are two types of bills, FinA bills and FinB bills. FinA bills are something which are kind of money bills only, and FinB bills they are not a classification under money bills. That means a bill or amendment making provisions for any matter specified subclassified from A to F of Article 101 Clause 1 shall not be introduced or moved except on the recommendation by the President. So it is saying FinA bills are introduced only upon the recommendation of the President. That we have already learned. However, if such bill is making provision for abolition or reduction of tax, it may not require prior recommendation of the President. That also we have seen that prior recommendation of the President is not required for abolition or reduction of tax. I thought this is under money bill. Yeah, money bill also. It can be a FinA bill also. So for abolition or reduction of tax, it do not require the prior recommendation of President. So what is FinB bills? They involve expenditure from the Consolidated Fund of India, and they should not be passed by either house of the Parliament unless the President has recommended to the House. But both FinA bills and FinB bills, they require prior recommendation of the President, except abolition or reduction of tax. Okay, that you need to remember. And Article 117 Clause 2 talks about bills that are not financial bills. Which are the bills that are not financial bills? Imposition of fines or other pecuniary penalties, payment of fees for licenses, fees for services rendered, imposition, abolition, remission, alteration of regulation of any tax by any local authority or body. So any local authority or body, fees for services rendered, they all are not a part of financial bills. Peculiary penalty, अगर कोई लोकल अथॉरिटी कोई फ़ाइन लगा रही है, दैट डू नॉट कम अंडर फिनेंशियल बिल. ओके, या फिर पेनाल्टी फी फॉर लाइसेंसेस, अगर बिना लाइसेंस के कोई गाड़ी चल रही है एंड कांस्टेबल ने फ़ाइन कलेक्ट किया, तो वो फिनेंशियल बिल के अंदर ऐसे सब चीज़ें नहीं आएंगी. फीस फॉर सर्विसेज रेंडर्ड, नो, दे डो नॉट कम अंडर फिनेंशियल बिल. सो कमिंग टू आवर कॉन्स्टिट्यूशन बैक, we have seen the definition of money bill. What is the definition of money bill? It is tuberculosis, TB, CA and CAR. Yes, and assent to the bills we already know. Annual financial statement, yes, we have seen a detailed table, and we have also seen Article 113 procedure in Parliament with respect to estimates, which is very simple. It just said that estimates matlab it is talking about a demand for grants. So demand for grants, they are split into charged upon expenditure and made on expenditure, that is demand for grants. And demand for grants, they are voted, and it said that the charged expenditure, they are not subjected to voting, and no demand for grant shall be made except on the recommendation of the President. So they demand for grants require recommendation of the president, and they are voted only in Lok Sabha. Okay, this is the procedure in parliament with respect to estimates. With estimates in the same with respect to appropriation bills indirectly. So when I'm talking about appropriation bills, so Article 114 says what is appropriation bill. It again says that demand for grants and charged upon expenditure charged on consolidated fund of India. Demand for grant expenditure charged on consolidated fund of India. See, it classified into clause 1 says that appropriation out of consolidated fund of India required to meet demand for grants and expenditure charged on consolidated fund of India, that we have seen. And expenditure charged upon consolidated fund of India, we have also seen that the same subclause 2 talks about no amendment shall be proposed to any such bill in either house which vary the amount or alter the destination. So no such amount shall be passed under the appropriation bill. However, in later we have seen under maybe under Article 115 the token grant, where to pass such bill we need a token grant again. Then we can to alter the destination or to change the change the expenditure charged upon the consolidated fund of India, we require a token grant. I think so. That is the meaning I have observed. Okay, now let us see. We have also seen supplementary, additional or excess grant. What is supplementary grant? It is the extra money charged on already established expenditure head. It is the extra money charged upon new expenditure head. Okay, excess grant, it is the extra money charged upon the excess money spent in the previous financial year. And we have also seen there is a new grant, token grant. It is inferred from Article 114 clause 2 which we have discussed just 1 minute back. And vote on account, vote of credit to exceptional grant. Vote on account, it is usually passed before 2017. Nowadays its demand got drastically reduced. It is just a temporary funding, especially during the election year. But during election year also mostly we proceed with the interim budget. And we have also seen the difference between interim budget and vote on account. Vote on account is a expenditure statement, whereas interim budget is a statement of expenditure and receipts, both expenditure and receipts. We have also seen vote of credit. Vote of credit is just a blank check. If there is any unforeseen demand due to natural disaster or war, then government is going to use vote of credit. And exemptional grant, under special if a special need arises, then the government is going to use exceptional grant. So these are some of the grants that can be passed by the parliament. Okay. Special provisions as to finance bills, it just says that there are two types of bills, FINA bills and FILB bills. It also says that it also talks about certain bills which are not financial bills. इसके अंदर हमने एक टाइप का बिल्स देखा. We have seen imposition of fines, fees on licenses, fees for services rendered, imposition, abolition, remission, alteration or regulation of any tax made by any local authority or body. So all these things, they do not come under financial bills. Okay, and we already know that Article 117 clause 1 was talking about FINA bills, which are type of money bills, and FINB bills, which are not money bills, which are financial bills. Okay, and now did we discuss the procedures, general procedures? I think we need to discuss them from 118 to 122. Then we will be finishing the legislature, I guess. So 118 talks about rules of procedure. It talks about rules of procedure. 119 talks about regulation by law of procedure in parliament in relation to the financial business, language to be used in the parliament, restriction on discussion, and courts not to inquire. Okay, let us see. Procedure generally, rules of procedure. Each house of parliament may make rules for regulating subject to provisions of this constitution, its procedure and conduct of the, okay, each house of the parliament may make rules. दिस इज़ द रूल्स ऑफ प्रोसीजर. ओके, एंड इसमें इंपॉर्टेंट सब क्लॉज ये है कि द प्रेसिडेंट आफ्टर कंसल्टेशन विद द चेयरमैन ऑफ राज्यसभा एंड द स्पीकर ऑफ लोकसभा may make rules. Okay, who usually makes rules of the procedure? It is the president. The president after consultation with the chairman of Rajya Sabha and the speaker of Lok Sabha may make rules as to the procedures with respect to joint sitting of communication between two houses. Okay, at a joint sitting, the speaker of Lok Sabha or in his absence, such person as may be determined. Determine the rules of procedure. Okay, at a joint sitting, the speaker of Lok Sabha or someone who is presiding the Lok Sabha may determine the rules of a procedure. Sorry if you are not understanding. During joint sitting, the speaker of who shall preside during a joint sitting? Is it chairman of Rajya Sabha or speaker of Lok Sabha? The speaker of Lok Sabha usually presides. Okay, during a joint sitting, the speaker of Lok Sabha or in his absence, a person as determined by the rules of Lok Sabha shall preside. That is the rule of procedure. Okay, usually rules of procedure they are determined by the president. President after the consultation with the speaker of Lok Sabha and the chairman of Rajya Sabha, he determines rules of procedure. Rules of procedure with respect to joint sitting of communication between two houses. Basically, I think each house of the parliament makes its own rules, but when it comes to joint sitting, usually the president after consultation with the chairman and the speaker, he makes rules for the joint sitting, and during the joint sitting it is usually the speaker of the Lok Sabha who presides, or on his behalf any other person as prescribed by the rules of procedure shall preside the house. So you understood the rules of procedure. Yeah, I'm sorry for confusing you. And let us go to Article 119, regulation by law of procedure in relation to the financial bills. What does it say? It says that for timely completion of financial business, Parliament can create special rules to streamline procedures. If rules under Article 119 conflict with the rules under 118, मतलब general rules of procedure for Parliament, Article 119 rules will prevail, but only for financial matters. Okay, you understood? If there is a conflict between if there is a requirement for timely completion of financial business, Parliament can make special rules, and if such special rules are in conflict with our previous article under 118, then the rules under this Article 119, the special rules shall prevail. Okay, and now it also talks about language to be used in the Parliament. It says that the business of the Parliament shall be translated in either Hindi or English. However, the presiding officer may permit a member to address the house in his or her mother tongue. It says even that कि हिंदी हो सकता है, इंग्लिश हो सकता है. अगर प्रिसाइडिंग ऑफिसर परमिट करता है तो वो मदर लैंग्वेज भी हो सकता है. That is the language that can be used in the Parliament. For the first 15 years from 1950, English for the first 15 years मतलब 1950 से लेके 1965 तक English was allowed to continue alongside with Hindi for all the parliamentary business. Parliament could decide to extend this period, which it eventually did also. Okay. Now Nirmala Sitharaman, she most of the time I observe her speaking in English only. Okay, so it can be Hindi, English or mother tongue. A restriction on discussion in the Parliament. No discussion shall take place in the Parliament with respect to conduct of any judge of High Court or Supreme Court. So 121 is important, 122 is also important. 121 restricts Parliament to discuss about judge of a Supreme Court or High Court in the about the discharge of his or her duties, except on the motion of removal. Except on the motion of removal or impeachment, the Parliament cannot discuss about judge of Supreme Court or High Court. This is the restriction on discussion in Parliament under Article 121. Okay, no discussion shall take place in Parliament with respect to conduct of any judge of Supreme Court or High Court in the discharge of his duties, except upon a motion of removal, impeachment of judge under Article 124 Clause 4. So that is about the Supreme Court judge, or judge under Article 217, that is a High Court judge. That is about Article 121. What does Article 122 say? It talks about courts not to inquire into proceedings of Parliament. Very clear. So courts cannot inquire into proceedings of the Parliament, and the members are very immune against that. मतलब during in the house, members can speak anything, and such whatever the member speaks, those things are not questioned in the court judiciary. Okay, so when I am back, I know the rules of procedure now. I know the rules of procedure. It just clause 1 said that each house of the parliament may make rules for regulating the business or for conducting the business of its or his or her own house. Okay, his or her nahi, of its own house. Okay, clause 2 says that the president, clause 2 हमने पढ़ा नहीं. Clause 3 it said that the president can make rules for the joint sitting. President can make rules for the joint sitting upon consultation with the chairman of Rajya Sabha or speaker of Lok Sabha. And that article 118 clause 4, there is also provision that at a joint sitting, usually the speaker is the one who presides, or if in absence of speaker, any person, it will be determined by the rules of procedure. Okay, who to preside, that will be determined by the rules of procedure. That is about rules of procedure under article 118. So next we have also discussed about article 119, which is regulation by law of procedure in relation to the financial bills. What is this? For timely completion, there can be special rules. Parliament can pass some special rules. However, Parliament can create some special rules, and but however, if these special rules are in conflict with 118, the rules under 119 shall prevail. And one more thing is that these rules are being brought so that there is a timely completion of financial business. So that is why the rules under 119 would prevail over 118 if there are any conflicts between 119 and 118. That is about article 119. And 120, it says it talks about language to be used in the parliament. It can be Hindi or English, or it can be if the presiding officer permit, a person can even speak in his or her local language. And restriction on discussion in parliament. So no discussion shall take place in the parliament with respect to conduct of any judge of Supreme Court or judge of High Court. Judge of Supreme Court under article 120, मतलब जज ऑफ द सुप्रीम कोर्ट को 124 क्लॉज 4 बोल दिया. जज ऑफ हाई कोर्ट को आर्टिकल 217 बोल दिया. ओके, दे आर बेसिकली अबाउट द जज of Supreme Court or High Court. And courts not to inquire into the proceedings of the parliament. Similarly, how parliament cannot inquire into the proceedings of the court cannot inquire into the proceedings of the parliament. So member can speak anything. Member has immunity power and they cannot be questioned in the court of law. पहले से देखेंगे क्या? So we have already discussed the constitution of parliament, composition of house of council of state, house of the people, delimitation commission, duration of houses, qualification for membership of the parliament, qualification for the membership of the parliament. We have read them alongside with the disqualification provisions, and we have also seen the sessions of the parliament: budget session, monsoon session, winter session, and who summons them? President summons them. President is the one who prorogues them. President is the one who dissolves them. But who is the one that adjourns or adjourns sine die? It is the speaker. It is usually the speaker. And we have seen the right of the president to address and send messages to the houses. That is article 86. And special address by the president. That is article 87. It is usually done before the commencement of commencement of year, after the first general election, or in the first session of each year. That is on the first day of a budget session. Okay, when the economic survey is passed. Usually that is February 28 or 29. No, sorry, it is January 31st, and budget is economic survey is passed, and February 1st budget is passed. Yeah, so on January 31st, president, there is a special address by the president. Right of ministers and attorney generals, they have right to take part in the proceedings, speak in the house, but they do not have right to take part in voting. Okay, मतलब ministers they can vote in Lok Sabha, मतलब if they are MP of Lok Sabha, but they cannot vote in Rajya Sabha. And coming to officers of a parliament, presiding officers, chairman and deputy chairman, the first 4 articles, speaker and deputy speaker, the next 4 articles. So we have seen the cases when there is a vacancy and when there is a resignation. So if you observe, it is only for the deputy chairman, it is not for the chairman. So vacation matlab if a member cease to be MP या फिर MP of Rajya Sabha, या फिर if he resigns to the chairman, if a member resigns to a chairman, or if an impeachment motion is passed by the Rajya Sabha by effective majority. So in all such cases the seat shall be vacant. However, when passing impeachment, you need to note down that a 14 days prior notice must be sent to deputy chairman. This is about a vacation of seat. Chairman and deputy chairman of Council of States. Vice president is going to be the chairman of ex-officio chairman of Rajya Sabha, and deputy chairman is chosen someone from the members of Council of States. Okay, and Article 90 we have discussed now, and Article 91, power of deputy chairman or other person to perform duties of office. So basically it says power of deputy chairman matlab kya? Deputy chairman can perform as a chairman if chairman seat is vacant. However, if a deputy chairman seat is also vacant, then the president shall determine who shall be the chairman of Rajya Sabha. Similarly, but what if chairman is absent? If chairman is absent, then deputy chairman will be acting as chairman. However, if deputy chairman is also absent, then who shall determine? The rules of the house shall determine who shall be the chairman. Okay, and coming to Article 92, who shall be acting? Of course, if the chairman seat is vacant, then there are going to be general elections later, but till then who is going to act as the president, that is determined by the president. Who is going to act as the chairman, that is going to be determined by the president. And the last is the chairman or deputy chairman not to preside. So during his removal from office, any presiding officer, whether it is chairman or deputy chairman, speaker or deputy speaker, they are not going to preside and they are going to sit in the house. Actually, chairman, he cannot sit in the house, therefore he has right to take part in the proceedings also, but he cannot vote in the end. He cannot vote even in the first instance or second instance, okay, because he is not the presiding officer anymore. Okay, and the speaker or deputy speaker, both of them are elected from the house of the people. And vacation and resignation of the, okay, how if he or she is not an MP, or what else, if deputy speaker resigns to speaker, or speaker resigns to deputy speaker, and next what, removed by a resolution by the Lok Sabha. So by then majority matlab effective majority. However, with the 14 days prior notice must be sent for such removal. And this is what we have seen. And power of deputy speaker. What is the power of deputy speaker? He can become a speaker if a speaker post is absent. But however, if even a deputy speaker is absent, then the rules of procedure determined. But if instead of absence, if there is vacancy, then the deputy speaker will become speaker. However, if deputy speaker is also vacant, then the president shall determine who shall be the speaker. So 93, 94, 95 was got over, and we have seen 96. The speaker and deputy speaker not to preside while resolution of his or her office from is under consideration. Yes, they will not receive. But if the speaker is not presiding, then where would the speaker go? Speaker is an MP, member of the house, so therefore he will sit in the house and he can vote in the first instance. However, he cannot vote in the second instance. Salary and allowances of the chairman and deputy chairman, okay, they are determined by Parliament by law, and Parliament has passed salaries and allowances of officers of Parliament Act of 1953 for that. And as Secretariat of Parliament, he is a highest ranking IAS officer who is a cabinet secretary. And there is a secretariat for both the houses, Lok Sabha and Rajya Sabha. Okay, and conduct of business. Conduct of business, we have seen oath or affirmation. It is the format is as set in the form as mentioned in the third schedule, and it is taken in the presence of president. मतलब जैसे कि usually it is taken in the presence of president. They are not a council of ministers. They are Remember that we are not talking about Council of Ministers here, oath or affirmation of Council of Minister. We are talking about oath or affirmation of an MP, and it is taking place in the presence of President. Actually, yes, every minister they initially take oath of office under oath of office as a member in the presence of President. However, the Council of Ministers later they also take oath of office and secrecy, that also in the presence of President. And for that, I think there is a special thing, special format that is mentioned in the article, in certain article in the Constitution itself. Okay, this is about Article 99 and voting in the House. Voting in the House, it unless specifically mentioned, it usually is through simple majority, and power of the House is notwithstanding vacancies. To act notwithstanding vacancies. Even if there is vacancy, that doesn't mean that the houses cannot act. And what about quorum? If there is if there is no quorum, that is if there is no 1/10 of total strength of that particular house, for example 1/10 of 54.3 543 is 54.3, 55 seats. If there is no minimum strength of 55 in Lok Sabha, then it is a duty of the presiding officer, speaker, to adjourn the house or to suspend the house until the quorum is met. Okay, and then we have read the disqualification of members. I am not going to discuss this because this is very lengthy, and I have already discussed it I have revised it with you 2 to 3 times, so I am not going to revise this. It is basically 101 to 104 and 102 has 2 clauses, 1 and 2. One is going to talk about A to F, which has unsound mind, undischarged insolvency, office of profit. Office of profit also had some of the exemptions like National Commission for SCs and STs and territorial army. They are not they do not come under office of profit. So whoever are disqualified under A to F are disqualified by the president upon the recommendation of the Election Commission of India, whereas so that thing that is mentioned in 103 clause 1 subclause 2, whereas a defection under the 10th schedule, it is so disqualification under 10th schedule is by presiding officer. So we have also discussed that 10th schedule is introduced by 52nd Constitutional Amendment Act of 1985, which introduced anti-defection law. Anti-defection law for MPs is 102 subclause 2, see 102 subclause 2, whereas for MLAs it is when you add 89 you will get 191 subclause 2. Okay, so we have discussed all this, and we have discussed that penalty is 500 rupees for every day. So every day he is going to pay penalty of 500 rupees if he sits in the house without any oath or affirmation. We discussed everything. Now we have also discussed power, privileges and immunities of members and its immunities of parliament and its members. Very immune to right to speech in the parliament. Until parliament mentions the privileges, parliament shall enjoy privileges as per the British House of Commons on the date of commencement of the constitution. So all that there are certain provisions, and also non-MP participant, non-member of parliament participant, for example Attorney General of India ho gaya, members who are not MPs, they also have right to speak, and they are also granted the same immunities in the parliament. So these are certain powers and privileges which are mentioned under Article 105, and in 106 we have seen salaries and allowances for members. For that we have salaries, allowances and pensions of members of Parliament Act of 1954. Similarly we have for presiding officers also, right? Salaries and allowances of officers of Parliament. Officers of Parliament matlab presiding officers, members of Parliament matlab MPs. Yeah, this is 1954 and this is 1953. मतलब स्पीकर्स के लिए पहला हुआ एंड बाद में शायद MPs के लिए हुआ 1954. ठीक है. Legislative procedures. We have seen provisions as to introduction and passing of the bills. We have seen if a bill dissolves, if Lok Sabha dissolves, then what kind of bills are going to be lapsed. The trick we remembered is that whichever bills are pending in the Lok Sabha, they are all going to be lapsed. Okay, one bill which is not going to lapse is that when it was introduced in the Rajya Sabha and it was still pending in the Rajya Sabha, only that bill did not lapse. The rest all of the bills lapsed, and other bills like bills which are introduced which are pending with the president or which are sent by the president for recommendation, returned by the president for reconsideration, and अगर president joint sitting notify किया वो सब भी lapse नहीं हुआ. So we discussed all of them. And joint sitting of both houses, article 108 mentions about joint sitting in certain cases मतलब during ordinary and financial bill. So it says that ordinary joint sitting is applicable except for money bills and constitutional amendment bills. So that is article 108. And 109 talks about a special procedure in respect of money bills. In respect of money bills, it says that Lok Sabha has overriding powers over Rajya Sabha. And 110 talks about definition of money bills. इसमें TA मतलब TA नहीं tuberculosis, TB, chartered accountant, CA and CAR. So this is about tax. B about borrowings. What is C? C talks about TA, CB. Next, what is that? CAR. T is about tax. नहीं TA नहीं, TB tuberculosis, chartered accountants, TB. हाँ TB. B is about borrowings. C is about custody out of consolidated fund of India or contingency fund of India. Borrowings out of consolidated fund, sorry, this is A, right? Appropriation out of consolidated fund of India or contingency fund of India. TB हो गया, CA हो गया, and then CAR. What is C? Charged expenditure, and declaring an expenditure as a charged expenditure. And A is audit of accounts of union and states. And R is about receipts of money in a consolidated fund of India or public accounts of India. So this is the definition of money bills. All such bills, they come under money bills under article 110. And we already know from a long back assent to the bills, article 11, they are the veto powers of the president. And procedures in the financial bill, we have discussed about annual financial statement very clearly, that it is divided into receipts and expenditure. Receipts are finance bills, that means where you can tax, and expenditure bill, where the government is spending expenditure upon, it has a demand for grants and charged upon expenditure. Okay. And we have also seen procedure in parliament with respect to estimates, with respect to appropriation bill. So what are the procedures in the parliament? मतलब यहाँ पे हमने बस प्रोसीजर इन द पार्लियामेंट, मतलब यहाँ पे वोट होगा या बस वोट नहीं होगा. सो वी हैव सीन दैट फॉर चार्ज्ड एक्सपेंडिचर देर इज़ नो वोटिंग, एंड फॉर डिमांड फॉर ग्रांट्स देर इज़ वोटिंग. Okay, and there is a subclause 3 which said that no demand for grant shall be made except on the recommendation for the president. So you are asking for demand for grant, and no demand for grant shall be made except on the recommendation of the president. So president पहले recommend करेगा, मतलब recommend करेगा demand of grant के लिए, and then demand for grant पास होगा लोकसभा के अंदर. One thing is that see, basically appropriation bill हो गया अंडर आर्टिकल 114. सो बजट में अप्रोप्रिएशन बिल होगा, एक तो रिसीप्स होगा, मतलब फिनेंस बिल होगा. अप्रोप्रिएशन बिल में ये है क्या है, चार्ज्ड एक्सपेंडिचर एंड डिमांड फॉर ग्रांट्स. डिमांड फॉर ग्रांट्स दे आर एज पर आर्टिकल 113 क्लॉज 3 जस्ट नाउ वी हैव डिस्कस्ड. ओनली प्रेसिडेंट, मतलब नो डिमांड फॉर ग्रांट shall be made except on the recommendation of the president. So this is passed only upon the recommendation of the president. However, this means that see, the council of minister is the one in the end who is advising the president, and this is binding upon the president. So the executive is the only one who can introduce demand for grants in the parliament. So that only on the recommendation of the president the demand for grants can be introduced in the parliament. So MPs cannot introduce a demand for grants in the parliament. Of course, that is something you know. Only the council of ministers, only on the executive. Only the executive. See, MP is different, council of minister is different. Council of minister is executive, comes under executive. So demand for grants, you are clear with this article. प्रोसीजर्स इन द पार्लियामेंट विद रिस्पेक्ट टू एक्सपेंडिचर. सो वोटिंग कहाँ पे होगा, वोटिंग कहाँ पे नहीं होगा, ये हमने डिस्कस किया 113 के अंदर. एंड 114 टॉक्स अबाउट अप्रोप्रिएशन बिल्स. अप्रोप्रिएशन बिल as soon appropriation bill matlab it said that it has two things. One is demand for grant and another is charged expenditure. This is mentioned in our 114 clause 1, and 114 clause 2 it said that no amendment shall be proposed to such appropriation bill which would vary the amount and which would alter the amount. However, there is a token grant mentioned in article 115. No, it is not mentioned, I guess. I am not sure, but the token grant, I think it can vary the amount, or if you vary the amount or alter the amount of in that appropriation bill, then for such thing you can introduce token grant instead of amending the appropriation bill. I think that is there. And we have also seen supplementary, additional, or excess grant. What is the difference between three of them? Supplementary is the extra money for already established expenditure head. Additional grant is extra money for a new expenditure head. And what is excess grant? Extra money for the excess money spent in the previous financial year. Okay, this is the difference. And what is article 116? It talks about three grants: vote on account, vote of credit, and exceptional grants. vote on account भी एक तरह का ग्रांट ही है. ये यूजुअली इसका डिमांड ख़त्म हो गया 2017 के बाद, क्योंकि 2017 के बाद डेट चेंज हुआ. बजट गॉट शिफ्टेड फ्रॉम February 28 to February 1st. So vote of credit, it is nothing but a blank check. It is a blank check, and it is usually used during unforeseen demands. Unforeseen demand, example war, natural calamity, etc. Exceptional grant, it is usually issued when a special need arises. When a special need arises and annual financial statement do not cover it, then in such cases exceptional grants are used. Special provisions as to financial bills. As per financial bills, there are two kinds: FinA bills, FinB bills, and it also talked about bills that are not financial. Example: fines, fees, services, and tax imposition led by the local authorities. So all such bills are not financial bills. FinA bills, they are type of money bills, and FinB bills, they are not a type of money bills. Okay, these FinA bills are also, maybe we can call some of them. FinA bills might be finance bills. फिनेंशियल बिल्स मतलब कुछ फिनेंस बिल्स या फिनिया बिल्स के अंदर हम क्लासीफाई कर सकते हैं. फाइन. एंड यू नो देर इज़ अ डिफरेंस बिटवीन फिनेंशियल एंड फिनेंस. प्रोसीजर्स जनरली, रूल्स ऑफ प्रोसीजर. आर्टिकल 119 talks about regulation by law of procedure in parliament in relation to the financial business. So what does article 118 talk about? It talks about the rules of procedure. It says that each house shall determine rules for his own house, but when there is a joint sitting, the president determines the rules of the house after consulting with the chairman and speaker of the house. Okay, and after consulting with presiding officers of both the houses, the rules president may make rules. And usually at a joint sitting, the speaker of the Lok Sabha is the one who presides the joint sitting. That is mentioned in the rules of procedure. Okay, if the speaker is absent, then the rules of procedure determine who shall preside the joint sitting. That is rules of procedure. And article 119, it spoke about what? Rules by law of procedure in parliament. Rules by law of procedure, it spoke about what did it say? I forgot. It created special rules. And it said that if there is, these special rules shall be utilized for timely, parliament can create special rules for timely completion of financial business. And if there is a conflict between article 119 and 118, the special rules under article 119 shall prevail. Okay, and 120 spoke about a language to be used in the parliament, and 121 spoke about restriction on the discussion in the parliament. Restriction of discussion in the parliament about Supreme Court judge or High Court judge. Okay, and 122 restricts court to interfere in the proceedings of the parliament. Okay, and coming to chapter 3, this is the legislative power of the president, that is the ordinance making power of the president. Shall we discuss parliamentary committees? If we finish this, then the topic of legislature is over. Maybe I will come up with a separate session where I am going to discuss about cabinet committees, standing committees, ad hoc committees, difference between all of them. I am going to discuss, because cabinet committees, I think they come under executive. So I will be telling you the difference between council of ministers and cabinet committees, etc. things in the next part. So there are 8 kind of there are 2 types of cabinet committees again: standing committees and ad hoc committees. So the 8 cabinet committees that are present are so these are all very confusing for you, so I am going to discuss them later in the next video. For now I will discuss the types of motion and finish the session. So these are the motions that can be introduced. One is a censure motion. It is used to express strong disapproval or criticism towards a government or minister. Okay. A censure motion can only be introduced in Lok Sabha by the opposition against a council of ministers or individual ministers. Next, closure motion. I am just saying कि it is a censor. It is not okay. Censure motion. You are sensing you are sensing that government, so you are showing strong disapproval towards the government or a minister. That is a censure motion. Okay. And now coming to the closure motion, it is used abruptly to end a debate on a particular issue. मतलब अगर एक डिस्कशन को क्लोज करना है, हम क्लोजर मोशन यूज़ करते हैं. फॉर एग्जाम्पल सिंपल क्लोजर, मतलब ओके बात ख़त्म हो गया एंड नाउ वी शैल पुट एवरीथिंग फॉर वोटिंग. मतलब चलो डिस्कशन बहुत कर लिया, अब हम वोटिंग पे जाते हैं. दैट इज़ सिंपल क्लोजर. Everything is put into voting. There is a closure by compartments where a lengthy resolution is divided into sectional compartments and each of the compartment is then put to voting. That is closure by compartments. And similarly there is a kangaroo closure where only the key clauses are debated and voted on and rest of them are bypassed and they are just considered as passed. Only the key clauses are debated and voted on. That is kangaroo closure. And guillotine closure, due to time constraints, the undiscussed clauses are put to vote with the already discussed ones. मतलब अगर कुछ क्लॉजेस का डिस्कशन होती है, कुछ का डिस्कशन नहीं होती है, बाकी सब का वोटिंग पे डालते हैं. कैंगरू में एटलीस्ट बाकी का वोटिंग पे ही नहीं डालते हैं. सो गुलिटिंग इज समवॉट बेटर देन कैंगरू. ओके. So you have understood the difference between 4 types of closure. Now let us see what is zero motion. Zero motion मतलब पार्लियामेंट में पता है ना 11 to 12 एक होती है, 12 to 1 एक सेशन मतलब एक टाइम होती है 0 आवर. सो 0 आवर के अंदर जो भी बिल्स डिस्कस किए जाते हैं, इंपॉर्टेंट इश्यूज़ के बारे में MPs बात करते हैं ना, तो वो सब जीरो मोशन से लेके आते हैं. सो MP दे इंट्रोड्यूस जीरो मोशन इन द 0 आवर. मेंबर्स ऑफ पार्लियामेंट कैन रेज इंपॉर्टेंट इश्यूज़ विदाउट फॉर्मल मोशन फ्रॉम 12 to 1 AM. दैट इज़ मतलब 12 को हम 0 से रिप्रेजेंट करते हैं यूजुअली. मे बी दैट इज़ वाई यू कॉल इट एज अ जीरो मोशन. व्हाट इज़ अ कॉलिंग अटेंशन मोशन? कॉलिंग अटेंशन मतलब एक अर्जेंट मैटर को अटेंशन लेके आना. सो टू ब्रिंग एन अर्जेंट मैटर टू द अटेंशन ऑफ अ मिनिस्टर, attention motion is introduced. Attention motion allows a member of parliament, मतलब attention motion allows a MP to bring an urgent matter to attention of a certain minister. मतलब finance minister को कुछ बताना है उसको, तो he will bring attention motion. It is an Indian innovation in the parliamentary proceedings which was introduced. So zero motion हो गया, attention motion हो गया, ये दोनों Indian innovations है. It is specified in the rules of procedure. Okay. It is similar to 0 hour only. However, the 0 hour is not specified. This is not so legal, but this is legal. Calling attention motion is legal and it is introduced in rules of procedure. मतलब 0 आवर में कुछ भी बात करते हैं बस ऐसे ही, आई थिंक सो. एंड व्हाट अबाउट प्रिविलेज मोशन? मतलब 11 to 12 क्वेश्चन आवर होती है, 12 to 1 0 आवर होती है ना, वही. एंड अ प्रिविलेज मोशन, व्हाट इज प्रिविलेज मोशन? इट इज़ रेज्ड व्हेन अ MP believes that a minister has infringed upon the privileges of the house by presenting misleading or false facts. Okay. The privilege motion aims to censor the minister involved. That's the privilege motion. What is the adjournment motion? It suspends the sitting of the house for at least 2.5 hours. We know what is adjournment. That is the same thing. It suspends the sitting of the house for at least 2.5 hours to highlight a specific matter of urgent public importance. And this adjournment motion, it requires the support of 50 members for its acceptance. And after that the presiding officer say the house is adjourned, so the house will be adjourned. So this is the adjournment motion, and for such motion to be passed, it requires the support of at least 50 members for its acceptance. 50 members, such a 50% of the members or 50 members? अच्छा हो, मुझे डाउट आया, ये 50% है, ठीक है. सपोर्ट ऑफ 50% ऑफ मेंबर्स. So this is clear. So it requires support of 50 members for its acceptance. Such a motion implies censure of the government, which is not, that is why it is not permitted in the Rajya Sabha. Because सी राज्यसभा इज अ कंटिन्यूइंग बॉडी, वहाँ पे कैसे सेंसर मोशन इंट्रोड्यूस हो सकती है. सो इट इज़ नॉट परमिटेड इन राज्यसभा. एडजर्नमेंट मोशन इट इज़ यूजुअली परमिटेड ओनली इन लोकसभा. नो कॉन्फिडेंस मोशन. No confidence motion, the ruling government must resign if it fails to show its confidence. That's all. That is no confidence motion, and it can be introduced only in Lok Sabha because it is the only one which can be dissolved. For the no confidence motion to be allowed for discussion, it must receive the support of at least 50% of the members of Lok Sabha. Okay, again I think this is 50%. I think somehow it is 50 members only because I have seen it as 50 somewhere, so let us put it as 50 for now. So let us say that for adjournment motion it requires support of 50 members, and similarly for no confidence motion also it requires support of 50 members, and there is no mention of no confidence motion anywhere in the constitution. Remember this. First no confidence motion was introduced in 1963 by Acharya Kripalani against Nehru government, because Nehru government is only the first government. The first no confidence तो वहाँ पे ही हुआ होगा mostly. So the first no confidence motion was introduced in 1963 by Acharya Kripalani. However, the highest number is filed against the Indira Gandhi government. Of course, it must have been Indira Gandhi government only, the highest number. Okay, coming to motion of thanks, it follows the president's address. At the motion of thanks, it's nothing but after the president address, the parliament must show its gratitude by expressing motion of thanks to the president. After the each general election, after the start of each general election session of for every financial year. Okay, and the president outlines so during the president's address, the president usually outlines the government policies and programs from the previous year and upcoming year, providing opportunities for the members to discuss, debate and criticize the government's performance. And this motion must be debated and passed in both the houses. Failure to do so signifies the government's defeat. So after the president's address, everyone should discuss about what the president has said, and the president everyone must pass motion of thanks to the president. And if motion of thanks is not passed, its failure to do so signifies the government's defeat. Okay, no day yet motion. If there is a motion which is accepted by the speaker but no specific date is set for its discussion, then such motion is called no day yet named motion. The speaker schedules a day or a part of a day after consulting the leader of the house, that is a prime minister, or the following the recommendation of the business advisory committee, either by the business advisory committee or consulting the leader of the house, that is a prime minister. A speaker finally schedules this. Okay, and then there is a dilatory motion. It seeks to adjourn the debate on resolution to slow down the progress of business in the house. Dilatory मतलब business of the house को slow down करने के लिए बस dilatory motion है और कुछ नहीं. It dilates the business of the house. मतलब अगर adjourn बार बार लेके आते हैं एक resolution बिना पास करके, बिना वोट करके, तो वो dilatory motion हो गया बस. And what about cut motion? Cut motion, it is introduced by the opposition MPs during the discussion of demand for grants in the parliament in the Lok Sabha. The cut motion serves as a no confidence vote by opposing the government's proposed allocation for the funds in the financial bill, for the finance bill, for the funds in the finance bill as part of for demand for grants. So मतलब फिनेंस बिल के अंदर जो फंड्स आने वाले हैं, गवर्नमेंट अपोजिशन को अगर ये नहीं लगता है कि वो डिमांड फॉर ग्रांट्स को सेटिस्फाई नहीं करते हैं, तो देन अपोजिशन माइट इंट्रोड्यूस कट मोशन which serves as a no confidence motion. If such a motion is adopted, it serves as a no confidence vote. The government is then required to resign if it cannot secure a majority support in the Lok Sabha. Of course, the Lok Sabha is only the ruling government because it already has majority, so it will secure the majority support in the Lok Sabha. So usually cut motion, I think it will not be passed. Okay, there are three types of cut motions. One is policy cut, economic cut, and third is token cut. Policy cut, it says that the demand should be reduced to 1 rupee, and economic cut says that demand should be reduced by some amount, and the token cut says that demand should be reduced to 100 rupees. uh, so basically, if you are see, I wrote a notes on that. See, cut motions, there are three types of cut motions. One is a policy cut. It reduces the demand for grant to 1 rupee. It means it is a complete rejection of policy. If it is passed in Lok Sabha, the government stands censored or defeated. So policy cut cannot be passed in the Lok Sabha, should not be passed. If it is passed, then it is the censure or defeat of the government. They are required to prove majority on the floor of the house to continue in the office. This is policy cut. What is token cut? It reduces the demand for grant by 100 rupees. Okay, this is token cut. It doesn't make an impact upon expenditure, but it is a formal method to register dissatisfaction with the government, or it is a way of showing that the policy is implemented in the constituency. मतलब अगर 100 रुपीज़ कट हो रही है डिमांड फॉर ग्रांट से, तो इससे गवर्नमेंट के एक्सपेंडिचर पे इम्पैक्ट नहीं पड़ेगा, लेकिन ये इंट्रोड्यूस इसीलिए होती है क्योंकि गवर्नमेंट के ऊपर डिससेटिस्फैक्शन दिखाने के लिए इंट्रोड्यूस होती है. सो दिस इज टोकन कट. सो पॉलिसी कट, इट कम्प्लीटली reduces the demand for grant to 1 rupee. To 1 rupee means it is completely rejecting the policy. That is token cut. That is policy cut. And token cut, it reduces the demand for grant by 100 rupees. So that is to 1 rupee, and this is by 100 rupee. And next is the economy cut. Economy cut, it reduces the demand for grant by a specific or a certain amount of money. That is economic cut. The objective, मतलब ऐसे नहीं कि टोकन कट में 100 रुपीज़, economic cut में ऐसे कुछ मेंशन नहीं है, but it reduces the demand for grant by a specific or certain amount of money. The objective of this economic cut is to reduce or rationalize the government expenditure. It does not involve the defeat of the government or censure element. It is just to reduce or to rationalize the government expenditure. So we have discussed the three types of cut motion. The cut motions are symbolic in nature as the government is in majority. However, if policy cut is passed, then it implies the government does not have confidence of the people's house. So usually the policy cut will not be passed. Next, the question hour. We know from 11 a.m. to 12 a.m. 12 noon, it is the question hour, the first hour in every sitting of the house. The first hour of every parliamentary sitting is slotted for the question hour. However, in 2014, the question hour was shifted to 12 to 1 p.m. in the Rajya Sabha. So, in the Rajya Sabha, the question hour starts from 12 to 1. So, during this 1 hour, the members of the parliament ask questions to the ministers and hold them accountable for the functioning of their ministries. It is regulated according to the parliamentary rules, and there are two kinds of questions mainly. There are starred questions, unstarred questions, or short notice questions. Starred मतलब they are very important, and unstarred मतलब important नहीं है उतना, and short notice question मतलब short questions. So these are these are some things that are related to question hour. Question hour of the Lok Sabha is different from question hour of Rajya Sabha. Question of the hour of the Lok Sabha is from 11 to 12 that we have already learned, but for Rajya Sabha post 2014, the question hour was shifted to 12 to 1 p.m. and 0 hour it starts immediately after the question hour and lasts until the agenda of the day is taken up. Under this, MPs can raise matters without any prior notice. So MPs कुछ भी डिस्कस करते हैं क्वेश्चन 0 अंदर के अंदर. They might raise issues of urgent public importance in the question hour also. So in other words, the time gap between the question hour and the agenda of the day is known as 0 hour. It is called 0 hour because it is starting at 12 noon, and it is a complete Indian parliamentary innovation, and it is not mentioned anywhere in the parliamentary rules book. Attention motion is mentioned in the parliamentary rules book, whereas 0 hour it is not mentioned in the parliamentary rules book. So with that, we have successfully finished the parliament, the union legislature. However, we are pending with some topics like we need to discuss the difference between council of ministers, the cabinet committees, and what are the standing committees, because I think cabinet committees come under executive and standing committees they come under legislature. And I'm going to discuss all the differences, and in the next video I'm also going to talk about what the functions of governor, the functions of a president, the functions of the speaker, the functions of deputy speaker, the functions of the secretariat, all of the main functions. Let us cover them in the next video. But we have finished union legislature, and the next session is going to be about state legislature, and after state legislature we are going to discuss about union and state judiciary together. Thank you.